everybody. Welcome back to Truth and Transparency. Today is Tuesday, all day, July 7th. This is live outside the courtroom here. The AP is out there. They've been out there for the past 40 minutes live. And then you can hear volume, and all of a sudden, see, right about they go silent right here.
Like kind of reminded me of Eileen Marks, Victor Marks' wife, and I feel like
They cut the mic, and so like everything now is you can watch, you just can't hear anything because they cut the mic.
What?
And so they're capturing all the vehicles come in. Obviously, a lot of press out there. Again, this is day 2 of Tyler Robinson's preliminary hearing. We've been covering it on over here, so welcome back. Good morning, everybody. I don't know why they just cut they're allowed to have their mic on. Like, why can't they? Let's talk about something really quick, though. Oh, wait, do we have a mic back? Maybe they just turned it really low. Look at that. Anyways, this is outside the courtroom. This starts at 11 o'clock Eastern Standard Time, 9 o'clock over there in Utah. So yesterday, day 1. So my quick recap here of day 1 before we go live with day 2. I just have to say a couple things. You either like love this judge or you're just like, dude, I'm not in second grade. Like, I mean, he's just so, okay, guys, the way this is going to work. I think he would have been a great kindergarten teacher or a teacher, period. Just the patience of this judge. Anyways, well, I was blown away. First witness. I shouldn't say I was blown away. First witness, a police officer on duty, Chris. And he's like, yep, start my day at 11. You know, like it's like I was on an overtime. He picked up this shift. He was working overtime. So, of course, immediately what I think about is, you know, party patrols. Oh, my God. They had like spots on the door like, hey, sign up for this. We can have some extra people here because Charlie Kirk's going to be in town. Well, then you come to realize that, no, they just had 6 officers on. That's who was scheduled, 6. They never debriefed on the fact that Charlie Kirk was coming to town. They never talked about it. There was no meeting. There was no, hey, this is your assignment. They didn't check out, you know, the roof. They didn't do anything. It was, hey, I got there at 11, got dressed, started my shift. And next thing you know, we're rolling around to right before 12 o'clock. And then right before the shooting at what, 12:23, 12:26. But a couple pow moments that the rumor of the holster is true, right? We've heard about that over here before. Now, was it taken into evidence? Was it not taken into evidence? It was just chilling, like I said, in that grassy area that's got the tiers. By the way, we do have, I was able to grab them off of Andrea Burkhart's channel. Again, I directed you guys to go there, watch it yesterday. The exhibits that the state could introduce, 1 through 33 or 34. So we found out a couple things about the UVU campus police. Basically, it would be no different than WSU. They don't have any drones, so they would have had to bring in a drone. So all the images from exhibits 1, 2, and 3, those were drone images, and those had to be significantly after the fact. So this holster, did you take it? Did you order anybody to go get it, take it into evidence? Nothing. Well, then we get the mother load of here it is. I wrote it on my community page. I said, you have got to be effing kidding me if you want me to believe that a guy starts a shift at 11 and he would have a fully like battery on full for his body worn camera. And on cross examination, so we noticed that you have 27 minutes of body camera footage on that you're wearing, and then it just stops. Well, how did that happen? The battery died. What? The battery died? You just got to work at 11. And then you weren't running it. Obviously, if you were running it the entire time, it would have been like 2 hours from, 11, right? No, what do you mean the battery just died? This needs to change. This has to change. We can tell when somebody powers off a phone. Okay. I want to know, was this powered off? And if you can't tell from whatever technology you're using for your body worn cameras, then you need to switch this. What do you mean what do you mean this just died? What do you mean your body worn camera just died? Anyways, then during Chris's, this is a police officer, during Chris's cross and direct, to ask questions like, let's talk about your police report that you wrote within a day or two of it. And when you want to talk about where you heard the shot come from, let's go right to that. In your police report, you don't say that you heard it from the east or you south or anything like that. You don't give any directional, nothing is in your report, is it? Nope. Nope. Wait, what? Come again? Yeah, you didn't note that in your report that where you heard the gunshot come from. Also, ready for this? Within 30 seconds of hearing the gunshots, or shot, I should say, you heard over the radio that they had somebody in custody. Within 30 seconds. That's what he testified to. From the time that you heard the gunshot, how long was it until you over the radio heard that they had somebody in custody? He said 30 seconds. Okay. 30 seconds. Wow. Okay. um wow. Okay. 30 seconds. Wow. Um let's see. The next statement I want to talk about. Well, we're finally getting to some truth here, which is, let me go to see my post. Okay. Um okay. Him testifying about the screwdriver on the roof, right? This screwdriver on the roof that he testifies to seeing, how about the picture that they use, the photo that they use? They use a photo that had the evidence markers in it already. Okay. So let me just put this in perspective of the Brian Kohlberger case. That would be equivalent to me seeing the sheath, not on anybody's body worn camera, right? and just a picture being taken of it when already evidence markers are placed down, and clearly it's not from my body worn camera, it's not my vision, it's nothing like that. It's you testified to a photo of a screwdriver, which is 3.1, and that photo of a screwdriver had evidence place markers in it. That's what the fuck we're testifying to, okay? So think about this. So your body worn camera did not pick up a screwdriver on the roof, because think you would remember that was a big argument of Ann Taylor with the sheath and talking about like, why didn't any of these body worn cameras pick up the sheath that was on the bed? Where was it? Like, is it because it was on the floor, or you know this that argument? Um, Again, we're talking about the first officer to testify yesterday, and I'm just like, wait, I cannot get past the fact that your body worn camera only has 27 fucking minutes, and you tell the judge and the world that the only reason that it has only 27 minutes is because the battery must have died. I don't know why. What? How is that possible when you just got to work at 11? How is that possible? Truly think about that. And see, if I'm a defense attorney, I hammer down with like, well, can we explain this whole body worn camera? You know, when you get to work, how does it work? You each have your own body worn cameras. And so like yours is specifically labeled like whatever your number is. They have a little like little tag on it some way, like a label maker. And when you get to work, like what are you supposed to do? Do you check your camera to say, oh wow, like does it notify you like you only have an out 27 minutes left? Because I can understand like your camera is your camera, but like the battery pack that goes with it, or are you just picking up from a wall? Like, here you go. I'm just taking here's a chart. Here's a full one. I picked this one and I just walk out the door with the battery that go to any of them. I would like hone in on that. I would hone in on the fact that so you were lazy because you would have known that it only had hardly any battery in it. How long can they last for? Like, how can we have body worn camera that's 8 to 12 hours on somebody? So you're like, you know what? I want that one. That one only has 20 minutes left. Get the fuck out of here. Okay. I just would have went into that whole process of how is it possible that when's the last time that you worked? So like, what do you do after you're done working a shift? Do you have to take your camera and take the battery off of it and put it on the charger? I mean, think about like, this just becomes muscle memory. When you go to bed at night, you take your phone and you plug it in so that it's charging. You know, you didn't ask anybody like, hey, can somebody come from so and so place? Like my battery died. I need another battery, like they were doing over there, at least in Moscow. We got these little kids doing this. You've been a cop for how long? 30 some years. The fuck out of here, man. I'm not going to listen to this shit. But I'm going to make this guy feel like if you're going to go the route, think about it. If I'm going to go the route to totally blast this investigation, I'm going to point out all of these things. Because you made it a point to say, oh, you only had 5 people on. Oh, you guys didn't do a debriefing. Oh, nobody talked to you guys beforehand. There was no meeting. There was no assignments. So why wouldn't you talk about the body cam and make it so ridiculous that there's no way? Can you prove that your body worn camera was not shut off versus that it died? Why wouldn't you ask these questions? And I get that they could say, well, it's only a preliminary hearing. Well, motherfucker wants to testify to seeing a screwdriver up on the roof. And I have no evidence that he saw this, just because somebody that processed the scene after him and he would no longer be a part of took photos. that he can say, yeah, that's what I saw? Excuse me? Well, you didn't see it like that because those evidence markers are down, right? Were those evidence markers down when you saw it? Are you sure? Making it really big, like it was staged, like the evidence markers were already there. Uh, you guys, this isn't some rookie cop, man. This is a guy that basically is double dipping. Okay. When I heard that he was a cop for 25 some years beforehand at some other place, okay, now he wants to come and just be on a campus. And like you said, oh, I picked up an overtime shift. I bet the fuck you did. Exactly. And this was going to be an easy thing. Oh, the Charlie Kirk thing, like, here, just come out for a couple hours. You can make time and a half. Let's find out who paid that. Was it a grant? Was it a grant that paid that too? Who else picked up overtime? Why were you? Who was working overtime at 11 a.m. for what? If it's not like, wouldn't it be for this event? So it blew my mind to hear him say like, no, we didn't have a debriefing session. No, we didn't check anything. No, we didn't go up on the roof. No, we didn't go over here, there, blah, blah, blah. We didn't do shit. Okay. Then what the fuck are you there for? Please. Then we get to second dude that testifies, the lead investigator with the accent. And that's where we get into something that I didn't know. But first of all, he says he testified that he watched over 100 hours of surveillance. Do you guys know like, how much? It's hundreds of hours of surveillance. Okay. Then this guy got camera footage from a guy named Olson, and that it was 16 hours of UVU footage. And that was 16 hours from 9:10, like right before it turns to 9:11, around the midnight time. And something that they're claiming is that they're able to put Tyler Robinson on that campus 4 times, which is 2 times before the shooting, and then one time after the shooting, but then one time right before it goes over into like that midnight time when it would become 9/11. And I'm like, wait, what? That's the one that was significant to me, is that you're saying that Tyler Robinson was on campus after midnight. Also, it comes out and as clear as day. Oh, hello. Duh. The guy on the roof, the guy, that Chris guy. Hey, when you were up there searching around, did you see any shell casings? You said you were like looking around for stuff because you felt that there was somebody in the prone position, blah, blah, blah. Nope. Couldn't find any shell casings. Wait, excuse me? There was no spent shell casings? Nope. There were no unspent, no spent, no nothing. What? Excuse me? Guys, that's all new to everybody, right? Okay. Awesome. Hella angles. We already know. We took a tour. There's hella cameras there on UVU's campus. There truly is. In all those parking garages, they have the fisheye. They have the circle shit. So I'm so interested in hearing about that. He was still on campus after and going into September 11th. So we need to keep an ear out for that. Then I want to point out they were not on to, they didn't know who this was. The second guy that testifies, the lead investigator in this case, he says he gets On September 11th, 2025, in the evening, someone wanted to turn himself in. So we've seen those photos in like the little clips that they put out. They didn't know who it was. They didn't have anything until somebody wanted to turn themselves in. He gets this notification on September 11th in the evening that someone wanted to turn himself in. And I'm over here like, wait a second. What about when can we talk about the photos of the rifle in the bushes and in the box and all this crap? So we're going to go over that. This dude's still testifying. So we're going to talk a little bit about that when there's breaks. And the big thing here that we're getting into is if they don't have a location data expert that testifies in this, okay, think about it in the Brian Kohlberger case. It's like, what are we going with? Because if he has his phone on him and it's turned on, right? Who's your location data expert? Because when you mix the location data mixed with the video, that's what's going to be significant, not this distinctive wheels bullshit. If you're relying on distinctive wheels, why do you need to do that? Why wouldn't you rely on fuck this Charger bullshit? Why wouldn't you rely on the location data mixed with the video surveillance that you have? That's what you would rely on. How about when the guy testifies to the medical examiner's report saying that the manner was murder? That is not a manner of death, okay? Did you guys catch that? I got a little chuckle out of that. Erica Kirk was there. Erica Kirk was recognized as being there. Charlie Kirk's parents were there. Taylor Robinson's parents were there. Think about this. This happened 2025. We are having a preliminary hearing in July of 2026. Andrea Burkhart feels the same way that I do. If you go check her, she did a recap of she did it live for 8 hours and then she recapped her own, live. And it's at the 3-hour mark when she was talking about the compilation of the videos of Tyler on campus because his lawyer objects. And it's basically like, we have some video that's like shitty. And then you have some clear video, and putting this all together. First of all, he didn't make it. And second of all, it's when you're mixing the clear videos with the shitty videos, it's having a false sense of like, oh yeah, it's gotta be. And so she objected to that, but it was funny because Andrea's like, kind of like the Elantra, kind of like the Elantra in the Kohlberger case. These just clear videos, and then there's just these grainy, shitty videos, and you're just going to say like, yep, that's the same car. And Andrea said it just like how I've been saying it. You guys act like they're a Honda Elantra is very, very common. And Andrea was talking about, that a Challenger is a common vehicle. What else do I have to say right now? They didn't have a drone up in the air while this was going on. I can't even believe that. Erica Kirk left a couple different times. They did a recorded statement of Lance Twiggs. I'm curious if this is going to get in. We're going to listen to that. DMC says, has the defense seen the gun? Last hearing, they said they hadn't. I don't think there was any. They didn't bring that up. Now we're gonna see. His lawyer objected every second. Yeah, I'm just preserving the record over here. Um, let's see. Oh, they go to try to do a first of all, let's be honest. Any of the videos that we've seen, you cannot make out who this person is, right? Okay. And so they go to ask the guy, have you, to give like a in court identification of like the video matching, like, do you see that person here today or something like that? And she objects and she's like, that's suggestive. And I'm like, it totally is. Because who else can you pick from? There's only one person sitting there. I'm going to pick the cameraman. Do you see that person here today in the courtroom? So I just think some of the stuff's ridiculous. You can testify to hearsay in preliminary hearings, but I just cannot believe that this preliminary hearing is happening in July. In July of 2026. I just can't believe it. And when I was looking at the exhibits that they're talking about, the recorded statement of Lance Twiggs, that was recorded on 4/28/2026. Okay. So when you're looking at the date that it was disclosed, I should say, not recorded, but the date that it was disclosed, when you look at all these exhibits that there are, there's a lot of things that are in October of 2025. There's a lot of things that are in December of 2025. We have a couple things in January of 2026, a couple things in April of 2026. And I think some of those notes are hard to read. I'll try to like zoom in on them over any breaks. Nestor said she was waiting on. Okay, so ATF report was done in 2025. The FBI DNA report for the towel and the screwdriver was done in 2025. The ATF ballistics report, 2025. So what is she? This is when the state is saying that stuff was turned over. I was under the impression that she wasn't getting things, and so that's why stuff was getting delayed. Obviously, that they were also doing other motions, but so we'll see. This starts in 3 minutes, they say. Hopefully they just get right into it. Yesterday is like, what the heck? Let's see. Oh, we got some movement with the camera guy. Do me a favor. At some point, you're going to have an opinion about this. Make yourself known. Here we go. Starts in, I would say, 2 minutes, but the camera guy just made some movement. He's alive. They may have some housekeeping. Yes. What is up, Mary? What is up, Murky? What is up, all the mods? everything in this case that they're using in this preliminary hearing as an exhibit was turned over and was disclosed in 2025, except for April 1st, a written statement by Mike Mitchell. April 28th, recorded statement of Lance Twiggs. January 9th, photo of burnt note from apartment. They are using nothing that I can see here from any location data. In these 34 exhibits. What do you guys think about that? This is wild to me. Wild to me. You're not going to have anybody testify to all the neighborhood canvassing video that you were able to find of Tyler Robinson and his car movements, and you don't have a location data expert that's going to testify to the phone and his cell and what the results are up in our lovely world of technology on cell location data. Nothing in a preliminary hearing. What do you guys think about that? Are we going to sit here and say that, like, I mean, I just went through the exhibits. I was like, I think we can almost, maybe they just figure like they don't need it. We don't need it. We're just going to go with the DNA. FBI DNA report, towel, screwdriver. ATF DNA report, rifle and cartridges. Photo of targets from a
case number 251
Oh, here.
403 576 State of Utah versus Tyler James Robinson.
I'm going to switch over.
Counsel, please enter your appearances.
We're not going to play with AP's volume. Wait, hold on.
Good morning.
Is AP going to give up the volume?
All right.
Kathy Nestor, Michael Burt, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated to my right.
Good morning, counsel. Good morning, Mr. Robinson. And for the record, the court all.
We're going to go with
Brief moment. And just let me know when it appears to be working. While we're waiting, if you have any water bottles or such, feel free to drink them. It is a little bit warm in here today, so I will be drinking from my water, so don't hesitate to use that if you need to.
Thank you there, Katie. How about them using those microphones yesterday? The ones that are like DJ. Let's go. Come on, man.
Is it working?
Speed this shit up.
Can you send them a link to the where this is being streamed so they have something to look at?
Who?
I see. All right. All right, let's go ahead and continue. And let me repeat it just because the audio may have cut out. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and still photographer, and I will invite you to come forward. All right, the purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you
All right, we're going to switch on over to Fox.
activities today?
Yes. Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No. No.
Do you anticipate any difficulty complying with the order or today or with the court's instructions?
No.
All right. Well, thank you. I appreciate your
Thank you.
cooperation today. As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly during all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during today's hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or opposing to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Turning now to counsel. Before we begin, I wish to acknowledge the professionalism, civility, and competence demonstrated by counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the court that each of you approach this matter with seriousness, preparation, and a deep commitment to your respective responsibilities. The court appreciates the care which you have taken in advocating for your positions and the respectful manner in which you have done so. Thank you. Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride will address the court.
All right, and just as a reminder, the microphones at council table are turned off to prevent the inadvertent capture of any communication. So if you would like to come forward, thank you. And turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved to find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing.
Thank you.
On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride. To defense.
Good morning, Your Honor. Michael Burt for
Good
Mr.
morning.
Robinson. We have no objection to that procedure as long as the court makes a ruling that the objections are preserved. We do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way. This court is not is acting in the role of a magistrate and will allow the parties to move forward as necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record, given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in and they shouldn't be, that they are redirected. I invite Agent Hull to return to the stand to resume direct examination. And Agent Hull, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way to dim these lights just a tad like we did yesterday? Perfect, thank you. All right, as of yesterday, there is also a water bottle to your left. And if you wouldn't mind just making sure that microphone is directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill, your witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to it yesterday. And I'd like to ask you again, have you reviewed that exhibit? And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation. He's running the summary videos from campus during
Okay.
Your Honor, excuse me, we can't hear the witness.
And that's what I hear. So let's go ahead and
Yeah.
stop. I'm not hearing it. So I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right, I believe that. Mr. Sturgill, if you wouldn't mind restarting.
I
so
can do that, Judge.
Thank you.
Maybe bring the mic from the base a little bit closer to you. If that'll help. All right, let's go ahead and go back to what's been marked as State's Exhibit 12.1. I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus
It does, yes.
on September 10th through the 11th, 2025?
Correct.
Okay. And again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay. Do you know who did?
The Utah County Attorney's Office.
Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video, again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
You reviewed this compilation with Mr. Olson, correct?
Correct.
And in its entirety.
Yes.
And he actually, and then you collected an 1102 statement from him.
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit, 12.1, in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3. And I ask that you scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus. So I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay, would you please read that sentence?
I have reviewed State's Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording.
Yeah.
Would
Have
like me to-
you, I'm sorry.
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance? Well, You review the raw footage yourself, is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes.
Okay, and when did you review that exhibit?
This morning
And who did you review that exhibit with?
with Kimberly Durfler.
Okay, was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked State's Exhibit 12.4.
And
Your Honor, we just object to the publication of this for all the reasons we argued yesterday. We think this video is going to play a big role in the trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
thank you. And Mr. Sturgill, and to all counsel, as it will apply to all counsel, when you are moving a piece of evidence, it's the three parts, whether admissibility into the record,
Right.
to be published in the courtroom, and captured by the media. So Mr. Sturgill, as it's your request, what are you requesting?
Judge, first of all, clearly I'd move to admit the exhibit. I'd ask, and Judge, the presumption is that this is a public record and should be published. And so the state's position is that it should be published here in the courtroom, and it should be published in such a way that the media can capture it on video.
All right.
Your Honor, can I be heard on that? Very briefly?
You may, if you would approach the lectern, please, and state your name.
I'm David Ryman. I represent the news media. I didn't make an appearance because the news media technically aren't parties, but as you know, they do have the right to be heard on issues like this, and I've tried to keep that to a minimum. But since this is the first one coming up today, I thought it might be helpful to just address it again. There is a presumption not just that it be published in the courtroom, as we talked about yesterday, because the participants or the spectators in the courtroom have a right to know what the court is viewing so that they can understand how you're making your decision. This seems like a very important piece of evidence. It doesn't seem like there is a basis to keep the people who are in the courtroom today from understanding why it's being introduced. It is not like the videos yesterday, and my understanding at least is, in fact, you can correct me if I'm wrong, but we didn't object to the videos that weren't published yesterday that were graphic. We didn't object to the non-publication of the autopsy report. The argument here that Ms. Nestor just made is this seems really relevant, and that is precisely why it needs to be public. With the last thing I'll address is just EMC. There is a presumption, it's a rule presumption, not a constitutional one, that EMC is allowed. And I think that for all of the reasons that we've briefed this for your honor several different ways, there needs to be a really good reason why. If it's being published in a public proceeding in the courtroom, it should not also be, it should not also be allowed to be published to the media. So,
Thank you.
thank you.
Mr. Sturgill, do you wish to respond or perhaps give a little bit more detail on what this video purports to show?
Well,
Yeah. talk about what it shows.
Do you want me to proffer that, Judge, or have the witness?
I'll defer to you.
Okay. Well, first of all, if I could take one step back, let me ask you, I may have misheard, but let's just be clear about this video, the compilation video. It includes video surveillance from UVU campus from what dates?
September 10th, 2025 into the morning of the 11th, 2025.
And if you wouldn't mind just describe in a bit more detail what this compilation includes.
The compilation shows the movements of the individual believed to be Mr. Robinson on Utah Valley University campus, arriving and leaving in a vehicle, arriving and leaving on foot, and then returning and leaving, and then attempting to gain access again in a vehicle. And his movements throughout the day are included in the videos also.
Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just want to clarify that. Ms. Nestor, given that additional information and anything further from defense?
Mr. Burt's he's the one who's been litigating all of the First Amendment issues, if he could address Mr. Ryman's argument.
Yes, Mr. Burt, if you wouldn't mind coming forward.
Judge, I wanted to clarify one argument that was made by counsel for the media yesterday, and that was the rules, the rule 4-202.02 does not apply to the situation we're in right now, and that is wrong. The rule says that this rule applies to the judicial branch, and 4-202.02J says the judge may regulate or deny access to exhibits to ensure a fair trial. So I think that rule does apply to our situation, and the Supreme Court in the Algier, ALLGIER case, 258 Pacific 3rd, 589, applied the rule in the context of an evidentiary exhibit. And I know the court has not mentioned, since counsel made that argument, this particular rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the evidentiary showing we've made in connection with our motion to exclude cameras, that there is a realistic likelihood of prejudice in this way. The court knows and has access to the media coverage up to the time when we litigated the motion concerning closing this hearing to the cameras. And the court knows that one feature of the media coverage has been a very pro-prosecution bias of every story that has been published on this account. The court also knows from that coverage that information is being widely disseminated, and you have found in connection with the shackling issue that the publicity in this case is likely to reach jurors who will be part of our jury pool. And we've also submitted to the court a public opinion survey, which shows that the prejudicial publicity that the media has already generated in this case has affected the jury pool. And so those are all factors the court can point to and rely on and conclude that publication of this particular exhibit should not be allowed because there is a realistic likelihood of prejudice to Mr. Robinson's right to a fair trial. So under that standard and under the rule, the court ought to deny publication.
Thank you, Mr. Burt.
Thank you.
Any final argument from the parties before the court issues its ruling?
Your Honor, can I be heard on that briefly?
Yes, you may.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree about what he said about the rule. What we were talking about yesterday was something different. That is the portion of the rule that classifies records that are in the court file. You know, it's not the same as what happens in a public hearing. And Mr. Burt referenced the portion of the rule that essentially just tracks the constitutional standard, which of course, you know, controls here as to whether in this public proceeding, it can be closed in any way, and non-publication of exhibits as a form of closure. So I don't necessarily disagree. I would just underscore a lot of what Mr. Burt just said has been briefed ad nauseum at this point. Their position that publicity is incompatible with a fair trial. The Allgaier case he mentioned, you know, I know that case. I litigated that case. It involved a confession that the court found public because you have so many other tools to seat a fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it in your ruling, saying pretrial publicity can coexist with the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty and difficult to overcome. And it is never satisfied, as we've explained, by just generalized assertions that there's a lot of publicity out there. It's got to be something really specific, and they just haven't made that showing. And I certainly don't think that a video that apparently just shows the defendant walking around the UVU campus qualifies.
Thank you. Anything further?
Judge, from the state, no, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with Your Honor.
Yeah, like
Thank you. I
that video is
appreciate
already
that.
out there.
Clarification as it is guiding for this court and making its ruling. I turn to Utah. Well, let me pull this up. So Rule 4-202.02. I go down to, well, first it says statement of the rule.
Oh, for fuck's sake.
1, presumption of public court records. Court records are public unless otherwise classified by this rule. 2, public court records include but are not limited to. And I'm going to go down to 2J, exhibits. But the judge may regulate or deny access to ensure the integrity of the exhibit, a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9, as those are different in nature. And those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims. And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. We can proceed.
Thank you, Judge. Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the Low-C building. Is that correct?
Yes,
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that
Nestler better make a note and say, what did you know at that time? She better ask that question. And how did you know it?
bear fruit?
It did,
you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
You testified yesterday that in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same attempt, that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess.
Yes, on each occasion, we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor what you're going to see is a paused or a still image. And I'm going to ask if you recognize what you see that now, Agent Hall?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead and I'm going to have this video run. And if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio. Is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start.
Why?
Your Honor, it's just not up on the screen yet.
Let's go ahead and put it on all screens.
Okay, here we go.
No, I appreciate it. Is so it is admitted and may be
In
published to
color.
the screens. And just want to make sure it's on your screen, Agent. All right.
8:29
All
a.m.
right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes,
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus.
Wait, that says 9:24 now.
At that time, he makes contact with some representatives from TPUSA.
By quad area,
Sorry, the amphitheater is what I previously referred it to.
so he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
Wait, what? No, that's not possible.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
There's a big problem.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then,
And
I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
Why aren't
And
you using
where
that
is
video?
that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And
goes where?
then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
From there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you?
Yeah, no, sorry. We already have some discrepancies over here.
Were you able to refresh your memory as far as the time?
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Now, what do we see?
So it's Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, we're able to track. We're able to track Mr. Robinson when he leaves this parking structure.
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive, as you can see on the video here. There is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
So right now, if we were to break this picture into quadrants, where would he be?
I would be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
And what time is this?
It's just afternoon, about 12:15
On what day?
on September 10th, 2025.
What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right.
Um, And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. I think the
It's,
timestamp on the video is 12:22
it's before that. Yeah.
On the 10th.
On September 10th, yes,
So we're
2025.
clear. This is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. Individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching,
Campus Drive,
and again, broken into quadrants. Where is he currently?
in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located? If you broke it into quadrants.
It's on the left side, on the upper side, the upper quadrant.
Now what do we see?
That vehicle's now pulling away and heading east on 800 South.
And why do you believe that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
And do you know who that officer is? or
Officer
was?
Goforth,
Okay. And do you know which department he works for?
Spanish Fort Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay. And what time was that interaction? I'm sorry. Did I ask you that?
It was approximately 12:30 a.m.
On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, or during the early morning hours of the 11th.
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently,
Wait, what?
when information was available that vehicle or a vehicle matching the description of that was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information,
Yes, he ran a partial plate.
a license plate?
Correct.
A partial?
And based on that partial license plate, he was able to identify the owner of that vehicle.
Yes,
What?
Did he tell you who the owner of that vehicle was?
he did, yes.
Okay, and who did he tell you that it belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
When did he tell you this? Oh my God.
Let's return again to Westbend Mark Stakes Exhibit 12.1. Again, you've reviewed that video.
I'm fucking
Yes.
dead.
And the difference between 12.1, or what's been marked as States Exhibit 12.1 and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
Yep.
And specifically, what be specific about the enhancements, and let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
Yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, Are they permanent red circles? Are they temporary?
I'm,
Something different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And this is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
All right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights, do they do anything with regards to
Object to
the
that.
video itself?
Objection. He doesn't not know because he just fucking said he's technologically fucking challenged.
Or is
Not-
this accuracy?
Not to my knowledge, no.
I think the next enhancement that has been mentioned that we've talked about is there's some blurring.
Yes.
Do you know what that, tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage and their faces were blurred. Excuse me.
Is anything other than faces being blurred?
Not that I recall, no.
And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed
Yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video,
No,
the accuracy of the video in your mind?
no.
Okay.
Unbelievable. Unbelievable.
Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1, are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the Losi rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that
Action
exhibit,
relevancy.
Correct.
12.4. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted to evidence. We believe there's enough foundation that at this point, we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4
Well,
words,
I
unless
can
you want to
read,
share that
I
with
can
me.
read that. Or
Okay, go ahead and
needlessly
read that.
presenting cumulative evidence. So the court may, let me just read the whole rule for
Why?
completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video,
Yeah.
and unless you have very, very, very good vision, or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it simply it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right. Well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is.
We need to see it. We cannot see it.
I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made.
We can't see anything.
If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court
He's
does
setting
not
a
find that
precedent.
the interest of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I
Okay.
appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
Okay.
And your intent is to review it in its entirety, but not here in the courtroom.
Yes.
Can I make
Admit.
one suggestion, Judge?
And review.
Or maybe one run request. I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really the thrust of why we are trying to introduce that exhibit, because
I see.
we believe that
Yeah,
it's
sure.
helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's
No.
been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did. But we had to memorialize it and save it, and then present it in that way, rather than just present it in its raw form and then have the ability to zoom in and out, if that helps.
I got it.
Your Honor, understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in. How long is that, Mr. Sturgill?
I think it's a couple of minutes.
Ms. Nestor?
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
Absolutely.
All right. Thank you. I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitor's council table and to the court's monitor on any portion that you wish to play for me to look at. So all parties can see clearly that the court is reviewing it in court, but I do not find that it is necessary for its publication because this is the exact same video. I recognize it's zooming,
Oh.
but in
I was
balancing
thinking it was an Argentina
constitutional
match.
rights,
two?
in
Today.
there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Council's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
I appreciate that, Judge. I respect that. I think there's a natural break where we can start. And what I'm going to ask is just we simply play the you will have this entire exhibit in evidence. So
Thank you.
Is that right?
Yes, I will. All right, whenever you're ready. Council, as it relates to your
games, 3-1-1 draws so far in this tournament.
Go Messi! Woo! Yeah! FIFA baby. Oh, sorry. Back to the courtroom. Back to the courtroom, guys.
monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring that complying by the rules, but in abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
So if I could just have one moment, hold on, Kimberly. Not sure where the power button is on that. There we go.
All right, counsel for defense, are we prepared? And for the state?
Yes, Judge.
All right, thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom. And you may present 12.1, the portion you wish for me to view.
Michelob Ultra is the official sponsor of the FIFA World Cup, so we bought some to support 95 calories.
And just for the benefit of the record, do you want to put on the record the timestamp of what you're playing, at what point you're starting and stopping? As we go, or when we finish is fine. I just want the record to be complete.
The difficulty in doing that is because we've zoomed in, it's removed the timestamp on it. And so
Well, you can just give me the
count
The
on the
count
video?
on the bottom. There's a
Ridiculous.
timer at the bottom of the total length of the video. So that's fine. I'm just trying to create a record of what exactly I'm looking at.
Pause on the court system.
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
I got a funny story. Take a look at my chat.
on the video is just before 6-minute mark, Judge.
All right.
I said, if you're a gay, can only play Paragays. It'd be a great game.
Thank you. I have it on my screen. So it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hall, can you see it?
Nobody's paying attention to what they're fucking talking about. So stupid. You're confusing the jury that does not exist.
And we'll play it. Go ahead, Kimberly.
What's up, Yuri?
It's playing.
Okay, what are we doing? I just want to say thank you. There's so many places you guys have watched the preliminary hearing, and here you are choosing to do it with TNT. It's 0-0. Argentina and Egypt in Atlanta. United States and Portugal both broke our hearts yesterday. I love the Egyptian coaches. I don't know why. They're amazing. They're just great. Again, this is day 2 of Tyler Robinson's preliminary hearing in the Charlie Kirk murder case. We are choosing to show Fox due to the enhanced audio. We don't show favoritism. We only show hearing favors. Okay. Okay. Allie Talley gets 5 memberships out to people. Yuri got 5 memberships out to people. And so did Kay Schmidt earlier. So 15 people turned green. It's still 0-0. They had a break. Argentina in the box. Oh my God, how do you miss that? Oh my gosh. Argentina just missed a gimme.
All right, and it's been paused, it looks like, at 6 minutes and 23 seconds.
I'm sorry. Judge, at 8:23, we stopped the video.
Oh, at 8:23. Okay.
8:23. That's the count on the video itself.
Thank you.
Okay.
All right. Thank you, Mr. Sturgill.
Agent Hall, you were able to watch that zoomed in version. Is that
Yes, sir.
right? Okay. And was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay.
Here.
And you can see clear the clothing that he's wearing.
Object leading.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection, and that you may move forward.
Is
Okay.
it easier to see? Strike that, Judge.
Move on.
I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
Oh my God, here we go.
Ms. Nestor.
Guys, just when we didn't think she was going to open up her fat fucking mouth, she does. And she says, objection, Your Honor. He's leading. He's been doing it the whole time. Oh my God. Maybe they're listening to what people are saying. But here it is, cross-examination. She had the night to prepare for this man. Let's see what happens here in this cross-examination.
Your Honor, if I may have the court's indulgence.
He was on the stand yesterday, so this is still just like witness number 2. Yesterday moved about as slow as a turtle crossing the road, but he's got the hair of a porcupine. Okay. So Nestor and her team had the evening to think about how to attack this man's testimony here at the preliminary hearing.
Thank you. Do you want to take the
And I was just going to suggest that. It seems like right now is a good time to take our morning break. Is 10:15. Let's come back at
10:30.
10:30, and we'll resume with cross-examination of Agent Hull. Court is now in recess.
All right, we're in recess. We're in recess. We have 15 minutes in recess here. The court. Okay. All right, I got it all the way up. All right, again, thank you guys for joining us here at Truth and Transparency. This is day 2 of Tyler Robinson's preliminary hearing. It is 12 minutes into the Argentina, Egypt round of 16. Messi. Oh, Messi's all over it. He's arguing his case. Okay. Oh my God, he just flopped. All these floppers. Okay, back over here. I don't know why she objected to this video that has been out everywhere, but I have an issue. Either level 1 camera has to be off. Okay, because level 1 camera said 8:29 a.m., guys, when he entered. And then basically he gets onto level 2, and level 2 all of a sudden shows him walk. It's very, something doesn't make any sense here. Something's wrong, because what I see here is him walking in at 9:24 and then walking out at 9:25. But also camera 1 on level 1 had 8:29 as entry. Okay. So, and I did the math, obviously, when you get up to level 2, you park your car, you get out of it, you would be like, 8. Oh, we just have a goal, I think. Uh-oh. The crowd, Jax is going crazy. Egypt sword.
Does come in this time. What a start made by Egypt. A goal from Yusuf Ibrahim. The central defender. Argentina won.
Oh boy. Oh my God. The Egyptians strike first. Messi's down 1-0. Oh boy. Jackson's going crazy. He's rooting for Egypt. I said, why? Wow. You gotta love the FIFA World Cup. If you don't, man, something is just, it's just so awesome. Okay, so I have some issues with this time. I want to know why we didn't get to see any Chick-fil-A. Okay, Michael McKee went to Chick-fil-A as well. So Tyler Robinson allegedly went to Chick-fil-A as well. Michael McKee got picked up right after he left Chick-fil-A. Here, Michael McKee's the case from Columbus. Here, they say that Tyler Robinson went there in the morning, then left, then arrives at 10:09, and he's on foot. He's still there. He talks to TPS USA. We're probably going to get into that, which is interesting. Then he leaves apparently to have Chick-fil-A, but we didn't get to see any video from Chick-fil-A. And then now they don't show, by the way, any of the, I guess, like they're not showing any of the video from like the cars that are on the Ring doorbell cams and stuff like that. They're not correlating it into their little compilation here. But here we go at 10 or 11:53. Here's the guy in jeans, the book bag, walking with the gate. And he manages to get this all underway, get on the roof, and lays down and then pulls the trigger. And then the surprising video, the last part, is at 12:30 a.m. on 9/11, right as it crosses over, is this vehicle supposedly talks to a Spanish Fork police officer on the corner, at 12:30, and they're saying that that's Tyler Robinson, and that this guy was just like, oh, this is a weird interaction. Let me just run a partial plate. We got to get way more into that. So here's Nestor's opportunity. This should be a good cross-examination. She has a lot of material to work with. Let's see where she goes with this. I don't even know. I don't even know what to say. We'll see. We'll see how prepared she is.
Well, the Argentinian comes up. Alina didn't do a great job on that occasion, running into trouble. Asura, Egypt, buoyed by that
Ooh.
goal. Zico with a flick into him, but he's been the final hit. And here is Messi, who has dropped into the keeper position to collect the ball. They get things together. Not the challenge coming in there, and it's a penalty.
Penalty kick, Argentina.
Mistimed it.
Foul inside the box. So Argentina will get a penalty kick here. Messi should probably take it. I'm so glad I have ADHD and can watch the game and listen to this. I know, right? Don't worry, I'll just be your guys' announcers.
Did not hesitate. Opportunity for Argentina to level matters straight away.
There was a reaction initially, and there's the gap in behind the fullback again. He's gone too late to press the ball. Whether he's onside or not isn't in doubt. And then as soon as he doesn't make contact with the ball, there's no real decision for Francois Texier to make. It's a blatant penalty late. He got there when he could, it was just too late. And an immediate response from Argentina.
Talking it over to Paul and the French referee. Lionel Messi, let's not forget, isn't always perfect. He squandered one.
All right, here we go. Messi's going to take the kick.
In Dallas.
Career penalty kicks, 114 out of 147. Last five, though, not too hot. He has missed a couple in his last five. Here we go. Whistle blows. Messi kick is blocked. He missed it. Not today, Messi. Not today. Oh. What a wow. Uh-oh. Egypt's bench got a yellow card. Messi's complaining. Everybody's losing their shit. I love it. Atlanta's on fire. Messi's kick was blocked. He went for the right. He didn't even go post. It was the easiest kick to block. Goalie didn't have to flex, nothing. Messi, what a horrible kick. Messi, holy shit. Ugh. Woo-wee. Not good. Not good. Wow. Here's a fun fact. Lionel Messi has missed both of his penalty kicks at the World Cup 2026. It's horrible.
What's the record scorer for Egypt? Also their coach. This the moment again.
It's hard, but not in the corner. And if you get it right as a keeper and you're going that way, you go early enough, and he went early enough. You get your power into your dive, you feel like you're going to save it. And it ended up being routine.
Again, we're just waiting here. They're on recess. They're back in 6 minutes. They're back at 10:30 their time, 12:30 Eastern Standard, and wherever you're watching. So they have 6 more minutes of the break, and then we're into cross-examination. The only new thing I'm getting out of this is the 12:30 video. But I cannot wait to hear this cross-examination of this Spanish Fork cop that ran a partial plate. I can't wait to hear about this. This is going on while Argentina is playing, so we're monitoring both.
Cool conditions because of the aircon here in Atlanta.
I think I'm rooting for Norway. Norway's my team that I think I'm rooting for now.
My goodness, temperatures have risen based on the opening 22 minutes of action. As Egypt in the lead, a goal from Ibrahim, and then shortly after that, a penalty award for Argentina. Lionel Messi unable to finish the job from the spot. Credit to Shabir. Gambled on direct.
Tina, what you got for us? Tina's pissed.
Looking to connect that tie with
Tina needs some answers on this. Why didn't you guys have the Chick-fil-A pictures or videos? You know, if you're going to talk about it, are you going to? You don't have the Chick-fil-A video though. Where's the video of like you're not able to track this vehicle out on any of the regular roads? If you have all these timestamps, like you don't have any of the roads. You know what I mean? Which again, this is just a preliminary hearing. You know. And then you have a totally different looking person with no vehicle arriving on campus. Okay. So without the video to show where this person originated from in this Charger, now you're just going to show a video at 11:53 of a guy that's dressed in jeans, and you're just assuming that it's Tyler Robinson. Like, how are you just saying that? So this is going to be really, really good cross-examination to say, you know, why wouldn't it be included that you followed him around from the time he left the second time to when he goes and parks a vehicle on some side road, remember? And we see this person walking, right? Why wouldn't that be included? I'm struggling to understand why that wouldn't be included when he's going to be talking about the movements of this person, right? And now he's just going to say, well, we just did the UVU videos. But why? Doesn't make any sense. What about, remember we talked about this? What about flock cameras? Waka, waka, flocka, flocka. Like, I don't know. Now, preliminary hearings are, remember, they're also strategic because whatever this person testifies to in this hearing, they can, if they try to change their testimony down the road, you're going to use a preliminary hearing and it's going to impeach them. So Nestor here should, I mean, if you're going to get this opportunity, this preliminary hearing is really, really important for your client. Otherwise, you would just waive it if you didn't want any of this shit out to the public. The public already has this shit. So stupid. So she should go to Pound Town right now. If Nestor doesn't go to Pound Town, I'm really sick and tired of these defense attorneys. Like, do you not know your case? Go to Pound Town. Let's go. We are at the hydration break. Messi down 1-0. Okay, back over here. 2 minutes. 2-minute warning. We are live from, see, you can see the camera shaking. You got the judge back there wiggling around, probably moving around. 1 minute, and we're supposed to be resuming. Again, we're showing the Fox coverage because it's an enhanced audio. So hopefully everybody had a good 4th of July. I bet you none of these people had a good 4th of July because they use basically like their 4th of July to have, I don't know, when should be prepping. So it's going to be forever. Yeah. Taylor Swift, Travis, married. I hope they start popping babies right away. That's my wish for them. We need to have a, there you go. Just ordered some Michelob Light from my neighbors. There you go. Michelob Ultra. Get in where you fit in. They are the official USA FIFA World Cup sponsor. So yeah, I think Taylor Swift should have a kid. Maybe they'll just go surrogate, you know? You guys ever follow the Ronaldo story about how he did everything? Yes, Canada, Mexico. It's everybody. Mexico lost, right? USA, Canada. We all just went down. Boom, boom, boom. No host city still remains. I thought Belgium. I mean, I thought we looked like shit last night, but that's just me. We didn't play well at all, and so like that's just kind of sucked to like, you know, make somebody beat you. I just didn't see that last night. I thought that Belgium has the way better bench, so that's a big strength for Belgium. They're not losing any when they sub. Come on, 12:31. What the hell? Let's go. What are you guys having for lunch today? What are we doing lunch-wise? Who's having Jimmy John's, Jersey Mike's? Oh my God, they put a Jersey Mike's in over here. Woo-wee! Love Jersey Mike's. Cannot believe that this preliminary hearing was like, do the math, like almost a year later. A preliminary hearing is supposed to be like 2 weeks later. It is July 2026. This happened September of 2025. August, September. I mean, almost a year. That is insane. Insanity. I'm having Michelob Ultra Light. There you go. Get it. Lana, you must be behind. I'm in the UK and it's 30 minutes on the clock. I don't know what you're talking about.
We'll go ahead and pick up where we left off. I note that the parties for each side are present in the courtroom, and we're picking up with cross-examination of Agent Hull.
Oh, gosh.
Ms. Nestor, your witness.
May it please the court, thank you.
All of a sudden.
Good afternoon, Agent Hall.
Good
You and
morning.
I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson. So when did you leave the SBI?
The State Bureau of Investigation?
Yes,
March of this year.
March of this year?
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So
Okay, hold on. Is the sound any better on any of these other channels? I just paused it. What the hell is going on? Like, we cannot listen to it like that. That is unbelievable.
When you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBA on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what
Okay, hold on. I'm sorry. This could not be. What do we got here? We're going to go to Law and Crime now. I don't know what she's doing, but it doesn't sound like that in Law and Crime now. So we're going to switch back over. This is absolutely craziness.
Okay. And once you came from on high, that preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured, and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th. Yes.
Which building was that, sir?
I don't recall.
Was
What?
that considered a scene that was worth preserving?
It was not. My recollection is that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I
What?
thought you said it was an unfired bullet. And now you're
That's-
saying it was a
that's correct.
cartridge?
When a weapon is cleared,
Uh-huh.
an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection. Is
Who
that
told you that? Why aren't you asking who? Also, that's what I think happened in the Delphi case.
that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Do you know where that bullet is now?
I don't.
Okay.
What?
So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were they were all ultimately cleared by you or somebody connected with you.
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun,
Any other guns that were found on the scene?
not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay, and just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
What?
Can we pull up?
What?
Exhibit Hole 13 and just show it only to the witness for right now?
What is it? I know it's 13. Here we go.
All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day.
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay,
Where's this gun?
thank you. Okay,
Oh, shit.
when did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
What?
And at the time you went up there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline. Is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
That looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes,
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
he prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes,
Separate from the one that's in this report?
yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
Where is it?
So, as of September 14th, Tyler Robinson had already turned himself in to the authorities. Is that right?
Yes, I believe he turned himself in on September 11th.
So, prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was? Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay.
This is what I said to go with.
And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation, or the second evening of the investigation.
Okay, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof.
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that. Is that right?
Excuse me. Determine who he was or
No,
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest and those images were released to the press.
You're talking about the ones in the stairwell from the
Correct,
from the parking garage.
correct.
But the video on the roof was not distinguishable. Fair?
That video as a standalone
Yes.
was not, no.
Okay.
Exactly.
And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you, at some point in your investigation, collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video
And ultimately, some screenshots were taken out of that video. Is that right?
by,
By you?
not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct?
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Yes.
And is this the moment where you are submitting that he was holding a gun in his hand?
As across the road,
Yes.
from my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay.
Crazy.
Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone. I
Right.
think it took longer for him to crawl into position
Okay.
and then establish a position
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay. Thank you.
How do you have time to get the casings?
I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct?
And it showed like a dead-on view of Mr. Kirk and
Dead on.
parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr. Kirk.
You're referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay. And can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct?
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
Yeah, sure.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you. Is it playing? Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that, at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that.
Okay.
But I can answer that question if I can view the video again.
Okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
Well, there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent
Yes, there's a videographer stood behind the tent.
to the right?
Yes, behind the tent.
Correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TP USA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience during when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you. All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured. And then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I
analyzed?
was not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
With my recollection, he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay. So you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
What was for other people ask?
You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
There you go.
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my head.
Do you know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble, yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Ms. Noble at that time.
Okay. Can we please bring up poll? Sorry, just a moment. Poll 48. This is Ms. Noble's interview. Do you have it? All right, do you remember that? Looking at that interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
I want to go back, if I can, to the scene itself, the preservation of the actual scene where where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed
What?
from the scene.
That's not
You
true.
didn't have to give permission to remove the tent,
Me, personally?
Right.
No.
so you're not sure when it was removed?
Nope.
And were you involved in the decision to pave over the dirt that was under the tent?
At UVU?
Uh-huh.
No.
Did you know that happened?
Only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Correct?
You received tips of death threats that Mr. Kirk had received the day before the shooting. Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was a
you.
confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay. And some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms of what you've described. I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Thank you, Agent Hall. I tender the witness, Your Honor.
Redirect by the state.
Bald and 3 people are in the car. What?
Just going to go back to a few things that Miss Nestor asked you about. First of all, the unfired bullet that you referred to. It's your understanding that that bullet was accounted for,
That's my recollection, yes.
okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of if on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. So there was a large rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they
I
carrying?
believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
When you said that it was possible that round was from an officer clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which
I'm
is
sorry?
we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars. So I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
And I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun in, or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point, after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Can you be more specific or describe in more detail?
It
what
appears
that item might
it
be?
appears to be black, and it appears to be longer.
Anything else about that item?
No.
No.
Get the fuck out of here with that bullshit question.
I believe it was Exhibit 9, State's Exhibit 9 that Ms. Nestor pulled up on the screen. And she
49?
had you look at that. And
The-
I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video. Is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner
Sure,
in that tunnel view.
yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that fair to
Correct.
say? Do you remember seeing the banner
Yes.
in the video? Okay, and
You're referring to the back of the pop-up tent?
correct, yes.
Okay, yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you
describe
can't see through it. It's white,
it? Right.
and you cannot see through it, no.
And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at. Is that right?
Correct.
And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot, what's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA. There are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
at least on those two occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of
They
the?
appeared to be the same.
You're aware that a rifle was eventually discovered,
Yes,
and was it your understanding that that rifle was discovered in a wooded area?
it was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
And that rifle was discovered on the 10th.
Yes,
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event.
yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
So managed by law enforcement. So
Correct.
did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes,
Okay. So identities of possible shooters.
correct.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes,
Okay. And that was the Washington County Sheriff's Office.
yes,
And you understood that he turned him, well, he showed up there voluntarily. Is that right?
correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Nothing further.
She better follow up with that. Told his family. Who told you that?
In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the Losi building, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position
Correct.
and then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you.
We have just a minute to meet with
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
She fucking sucks. I didn't follow that much with the Corey Richards case, but I thought she sucked for whatever I saw her do there. I thought she just had a very poor, her whole team was just really poor with how the jury would perceive them and how they just carried themselves. Demeanor, her decorum. I'm just not a fan of this lawyer. I mean, at the end of the day, it doesn't matter if I'm a fan of somebody or not. I would have clarified some things here about, okay, you guys were able to track back him going to this campus on other occasions other than on the 10th. You know what I mean? Was he by himself? Or are you talking about you've never been able to track him to going to that campus any other time? Like, I just would, I don't know. There's no jury here, so it's just like if the magistrate understands like what's going on. But the lead investigator's like, I did not follow up with any of those death threats. I did not follow up with shit. I just didn't do any of that. I want to know why Nestor wanted to bring up the fact that it was Tyler Robinson's Boy Scout leader. Now, people are not probably going to appreciate me saying this, but we all know that a lot of things have occurred with their Boy Scout leaders, potentially touching their Boy Scouts. But I just thought that was interesting that Nestor wanted to make the point that it was Tyler Robinson's Boy Scout leader who also had ties with like law enforcement. Was that necessary? Because I feel like you're saying that for a reason. And it has to be two reasons, in my opinion. You trust that person, right? They're your Boy Scout leader. Like, that's someone that you trust. But doesn't he trust his parents? I mean, I don't know. And you don't want to maybe like clear up the fact when it's like, why did he turn himself in? Well, he told somebody, I was told that he told his parents that he was involved in the shooting. You don't want to find out where that came from. I don't know. Maybe she already knows, but you guys, I've said this so many times. You put it on these judges that like they know the case and they just don't. She didn't want to clear up any of those, the timing of the parking, just to make like this 8:29 a.m. And then all of a sudden like level 1 says that, but then level 2 says, I would have so many hella issues. Maybe she's going to bring that up with like a different person because it's like he didn't put that video together, but still he like looked at it. This whole bullet bullshit, that is the same thing. Would he testify to here? Wouldn't it like, that's what we try to get across in Delphi, that bullet came from a fucking cop, came from somebody that it came out of their service weapon. And that the cops knew that. Whatever. But it also looked like it had been there for a while, but how he explained that that's normal and that happens all the time. Fuck, you couldn't get a cop in Delphi in that case to testify like that. I'm just mesmerized by the fact that Tyler Robinson could just get right up there on that roof and just get to town, plant down, boom, laid prone for just 15 or 30 seconds. Oh God, something's going crazy. 2-0 Egypt. Jax is losing it down there. Gotta take a look at what's going on in the Egypt game. In the Argentina game, Jax is losing it. Hold on. He took off his shirt. Oh my God, they just scored. Up.
No transgression. He's looking for it, desperate for it. This is very much part of his game. It's a fabulous run.
Oh my God. He left the goal. He pulled a USA. Oh wow. Egypt comes right out of the locker room. Scores. Oh my gosh, 2-0. Holy Lionel Messi. They're looking for the foul. He went coast to coast, baby. VAR up. Oh. And he pulls his jersey. I think it's coming back. I think it should come back. I think it's a foul. The goal is under review. Here it is.
After review, careless tripping committed by number 19 of Egypt in the offensive phase. Final decision is goal cancel, free kick. Well, you heard it. Free kick. Now let's bring in Dr. Joe Magnick to get a bit of clarity on that one.
All day it was a penalty. Now Jackson's losing it the other way.
Resulting the goal being disallowed and coming back and giving the free kick.
Now Argentina free kick.
That's the player in question, Zico, who thought
Gotta love it.
he had made it to Egypt. Not so.
What a let-off. What a let-off for Argentina. The full length of the pitch.
Oh, I gotcha. I don't think they're gonna do it here though.
Free kick to Argentina.
Lana loves and don't blame.
The head flick by McAllister.
Can you imagine if I'm just like, hey guys, we're really not gonna watch the Charlie Kirk hearing and come listen to the Argentina game.
On the back of what has just transpired, Rob.
Messi corner.
Messi with the corner.
Oh gosh.
Hands on deck for Egypt. So by
Talk about a swing. It should have been.
still just the one.
Oh, Ronaldo got fouled yesterday. They didn't call it. That was some bullshit. I cannot believe they didn't give him that call. He should have totally been kicking. That would have obviously changed the game. They would have scored first.
But they're back 100 yards away.
60, so we got 30 minutes left, plus extra time. Plenty of time for these seasoned veteran athletes.
Referee saw the tackle, decided not to give it, and then Egypt with a brilliant breakaway goal.
Up,
Have been denied a two.
another breakaway. Egypt.
Here's Salah. Probing.
No.
Certainly plenty had to happen after that infringement before the goal was scored.
Okay, Nestor only needed 5 minutes. Don't know why she needed 5 minutes. I mean, it's just going to be right before. She's probably now just going to say, can we just take our lunch break? I mean, what time are they going to lunch? They should just take their lunch break right now. Anyways. Lana, you ought to be able to destroy all that security footage BS in 30 seconds. We just had to watch. I'm sure you are. Yeah, it's bad. It's bad. And I just think it's crazy that they didn't include I know what they were doing. They only included in that little compilation UVU video. Okay, but we should all ask ourselves why. They didn't have to. They chose to. Why? And I think there's a huge argument to be made. You cannot just assume that. You cannot speculate. Like, what the how it looks in the exhibit here is that Tyler Robinson, who they're claiming was in a maroon shirt, okay, shorts, that's whose vehicle comes in, okay, and that person with that outfit gets out of the vehicle. Then that vehicle leaves, okay, but I have time issues with all of that though. But that vehicle then leaves. Then the next video you have, he then walks on campus. Then he leaves. Then the third time that he comes back is at that 11:53, and he's in jeans, that long sleeve shirt, and he walked again on the campus, and they're not showing this judge a vehicle or anything like that. So they are asking the judge to believe that the maroon person is also the same person as this guy with the hat on and the jeans and different outfit. And now my thing is I want to do this timeline, and nobody wants to talk about a timeline. This guy just flat out says, I didn't do a timeline. I mean, I did one throughout it, but I didn't do one prior to September 14th. And he had a perfectly good question, which was, so you then relied on this other dude, Davis, who he's going to testify. So I just can't believe that Nestor didn't ask, where did you hear that my client wanted to turn himself in and told his parents that he did it? Where'd you hear that? Who provided you that information? But there's a reason that she didn't ask that. So Lana, I just noticed that you don't have your screen up. No, I can put it up. I don't have it up right now. Sheila, what's good, girl? Come on, let's go. Take your. They haven't done their lunch break. What are we having for lunch? It's already It's 1:30 here. Did they already do their lunch break? This should be lunch break. I'm confused. Take 5. This should be lunch break. Are they even going to come back and say that it's lunch? This should take us to lunch break, and they shouldn't be back for like an hour. So I don't know what the fuck they're doing. Bunch of idiots. He should have said, well, looking at the time right now, we don't need to take 5. We need to take an hour for y'all to have lunch. Look at this shit. Charlie Kirk's accused killer, Tyler Robinson, is back in court this week as prosecutors begin presenting evidence during his preliminary hearing. Robinson is charged with assassinating Kirk. And the week-long... Uh-oh, something happened. Jax is losing it again. It's supposed to be expected to be including surveillance video, forensic evidence, digital records. I don't think they're going to be showing that many digital records. And testimony aimed at determining whether there is enough evidence for the case to move to trial. Jeez. Tyler Robinson better aim than Messi today. Amy says the bullet don't match. Tyler Robinson is just 5'10". Tons of ways to do an analysis of the person's height walking up the staircase. I agree. So many things could have been done. This has been almost a year later. How are you having a preliminary hearing? Like WTF? 2-0 now? So now it's really 2-0. Parents did not turn him in. I don't see that either, but I don't know why Nestor didn't come back and ask where he heard that from, you know? I do believe this is going into the lunch hour, guys. Just want to give you guys a heads up about that. This would make most sense to me, but I was expecting like the judge to come out and say that. Oh, wait, but it's only 11:32 there. So hang tight. I forget my lunchtime. I'm like, yeah, dude, I got to have lunch here. It's 1:33. I haven't eaten lunch yet. I think I'm going to order myself a Jersey Mike's. God, all the big dogs. You're just giving it. You're just being able to give it to France. Give it to, I'm rooting for Norway, I think. They're emerging. Even though I really love Mbappe. Holland's just been amazing. He's embraced the States. He's a great story. Where's all my Norway people? Yeah, but that's the thing is nobody caught the suspect. The suspect wasn't caught. The suspect turned himself in. So I don't think anybody caught anybody. And I think you could tell that in this. I think Taylor Robinson is effed. Someone says, yeah, I mean, who wouldn't be effed when you have every agency working against you? They're not working for you. Tyler Robinson's team is doing fine. We'll see. We'll see. I mean, fuck, she had 10 months to prepare for a preliminary hearing. So I hope she's doing all right. Ooh. You know, you got 10 months to prepare for a preliminary hearing. Wild. Mm-mm. 1966 to 2026. I know. There it is, Dean. Dean's like, yeah, look at me. You gotta feel pretty good about, how things are playing out, right? He has a chance to win. I think he tied. What's everybody have? However many goals? 6? Where are they at? 7? 6, 7. Get Jackson double meat. Yeah. Oh, he's losing it. He's losing it down there. Let's give a ring. Hang tight 1 second here. We have movement.
Session.
Oh, back in
We
session.
left off with Agent Hull was excused, and we are proceeding. Mr. McBride.
Yes, Your Honor. We intend to call Jennifer Faumlina, but before I do that, I'd move the admission of States Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Engelhardt from Turning Point USA.
All right.
And yeah, again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102 because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person. So it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that
prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to.
I appreciate that. I bet you do, Judge.
Well, so here's my question for you, Mr. Novak, as you're, and again, I appreciate your discretion and highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance. And if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the 3rd person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3. Paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the 2nd paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is. And I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence. And there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Engelhardt's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Engelhardt says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay, so paragraphs 2 and 3 include not only Mr. Engelhardt's opinions, and now
Who
I'm going
gives
from
a
relevance
fuck?
to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence,
Lay.
but it's Mr. Englehart's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible.
What is this?
And
What?
he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
It's 2-2. Oh my God, messy.
And as the court knows, but I want the record to be clear, when I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about when, or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking
Oh, come on.
Mr. Kirk's political expression.
Messy.
And now I'm
Is that
quoting the
messy?
statute as the personal attribute
Messy scored.
that the state alleges
2-2.
is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging.
I object, Your Honor. Messy just scored. It's 2-2. Can we take an early lunch break? This shit's getting real heated over here in Atlanta, okay?
I should say there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. Subsection, I'm sorry, the 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values
What
that
the
he
fuck?
believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not,
Are we serious right now?
is not relevant. And that's why we think it should not be received into evidence.
Why did this take
There's a
so
second
long to
level here.
explain?
Which is Mr. Engelhardt's statements about what is in the Bible.
Mr. Engelhardt, bless your heart, but like wherever this man is that wrote this and that he's arguing against, like this does not need to come in. Like, what are we doing here?
Specifically Matthew chapter 9.
Matthew-
So I would just ask this court the hypothetical portion of the Bible in order to prove this enhancement. Because I can't see where else it fits into this case. I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter
This is embarrassing by the state.
here in this proceeding what the book of Matthew says.
Oh my
It doesn't matter
God.
what Mr. Engelhardt thinks. And again, I say this with all due respect to Mr. Engelhardt. Who I
No, you
never
don't.
met. The book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives
Of the Bible.
within the sort of the heading of religion.
It-
But
It shouldn't
it
be
doesn't really
even.
matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. that's your honor. There is nothing in this that helps the court resolve with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the target enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice.
I'm sorry,
The
but
403 here is that receiving this document into evidence
prove
is
motive. You don't have to.
going to
just
create
want the
confusion.
enhancement.
It's going to create chaos,
Mm-hmm.
Not by the trier of fact, but by the future jury pool in this case.
Oh God,
For
yeah.
this court to make a ruling that Mr. Englehart's opinions about religion, about TPUSA's views on religious matters, that
It's
Mr.
gonna be a
Kirk's
religious-
views on religious matters are in any way what this case is about.
Do you know what it's going to do to a jury when it comes time to deliberate inside that jury box and in that room, and people start going at it who have different religions? That's ridiculous. That should never happen. Oh my God, Argentina just scored. Oh my God. Oh my God, in the 92 minute. Oh my God.
Is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Englehart's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. When I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Englehart for some specific evidentiary purpose, that I'm
The Egyptian coach just got red carded. Oh my God, there's a fight. It's a brawl.
missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak.
Oh my God.
Turning to the state.
Just-
And so just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes, Rule 104
This is
requires the court to
ridiculous.
consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has 2 roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to confuse the issues in this case and create fair trial risks for Mr. Robinson.
All right. Thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding, but I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and And to their right to fairness requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in courts, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to say, constrain you from saying, well, I don't know what you're going to say, but I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride in regards to your response, the rebuttal to the argument by Mr. Novak. What is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, if the court rules on that, I will make my full argument.
Get the fuck out of here.
Well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your clients, and every attorney should be doing that, that is your
The people
duty.
of Utah.
I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully, be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about There's no ambiguity without quoting it verbatim in open court.
This is such bullshit.
No, I don't think so.
All right.
Your Honor, if you're going to make a closure ruling, I'd like to be heard.
All right, I'll hear from you as well. If you would like to come forward, again.
That's what Ann Taylor should have said. Ann Taylor should have been saying all of that shit. No.
Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Here
Sure,
we go.
thank you, Your Honor. David
Media.
Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kern's Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kern's Tribune also speaks to this, and that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kern's Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, you know, a closed session or a sidebar or however, you have also done it in chambers. I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, and it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment, it's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
Exactly.
Thank you.
This is not fucking brain surgery. I don't understand what the
Anything
fuck is
further,
going
Mr.
on.
McBride?
Just to note, I have not made my full argument on admissibility. That's all.
All right. All right, I appreciate the arguments by the
Show me that
parties.
smile.
This is clearly something that's very important to you all and is important for this case,
Egypt
as
blew
is
it.
every piece of potential evidence. I note that
It's the cabal, everything. Motherfuckers.
Mr. Novak indicated that receiving this
Fam's
would
pissed.
create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder. And whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information going to the very beginning, whether this is relevant. And as noted by counsel, looking to count one, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything, but what is before this court under count one, aggravated murder, which is a capital offense, victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson belief or perception regarding Charlie Kirk's political expression. And so if that was not here, this enhancement, and it also goes to count two, felony discharge of a firearm causing serious bodily injury. and I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds. But at this point, the court finds it is relevant for consideration, and if for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur, and in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3. That these events discussed political issues as well as religious issues. Most political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses. It talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant, I don't see
Growth
the
identity.
prejudicial effect, unfair prejudicial effect this would have on the fact finder, whether or not it has, some capability of prejudicing the potential jury pool. I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here. And, but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Admit it and move
So move
on.
back.
Thank you, Your Honor.
There we go.
For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind. And that's what motive is. And that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the alleged allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views. That's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that. And that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually the state doesn't have to establish motive. Motive is not an element of the offense, but at least with respect to the victim enhancement, according to the legislature, the question is what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit.
Yes.
So what we have in this document are what I think are purport to be untested expert opinions or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document?
Thank you.
That Mr. Robinson had disagreement
Exactly.
with Mr. Kirk's political
Yes.
expression.
Exactly.
None of that appears in this document. There
That
may be other evidence of that we'll have to see, but there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind. Because he
exactly.
doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious
Biblical
doctrine,
scripture.
and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court
His
concluding
religious
what
beliefs.
Mr. Kirk thought chapter 19 of the Act
Exactly.
means?
I mean, this is ridiculous.
So it's not relevant. It's improper opinion evidence.
Fuck yeah, it is.
It's definitely overbroad in terms of the
It's not
evidence that the state
necessary.
is proffering to prove a very narrow point. And it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically that Mr. Robinson may or may not have heard. Nor has the state presented any evidence. And as an officer of the court, I would say I don't think that the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue
Specific.
that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself. And so I'm just going to stop unless the court has questions.
I don't. Thank you. Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
Not this dude
I
who
think
gives,
that's a great question,
who
but
gives a
probably
fuck
not
what
a
he thinks,
question
though.
to be answered by me in this proceeding. That's actually a really, really complicated
jury.
question that the state wants the court to say is a simple yes.
All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written,
Yes.
is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it. You said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to give
Because they put the Bible into play. What the fuck are you talking
a
about?
little bit of guidance from your position. And so that's the reason for the
No,
question.
I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression.
Yeah.
The state selected the victim targeting enhancement based on political expression only.
Not really.
Now the state wants to I didn't bring Matthew in.
Yeah.
The state is bringing Matthew in through Mr. Engelhardt.
Yeah.
I didn't bring the Bible
Matthew
to this
is
courtroom.
the
The
Bible.
state brought it. And that concerns me greatly.
Thank you.
Because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem.
Mm-hmm.
And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
What? How can somebody
Right,
else?
in making this determination
there
whether
should be
it's
a talk.
admissible or not,
Fuck that.
I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant? What is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression. And the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence.
Provisionally.
And at such point, when it becomes relevant, based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed.
Oh my
Well,
God.
let us proceed to lunch because
I
it
was
is
going to
now
say,
12:40. It
Let us-
seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's go
everyone looks like they want to puke in there.
come back at, let's come back at 1:15. Well, okay, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
No, Your Honor.
All right. Court is in recess until 1:45.
Amazing. What a mess. So stupid. Dude, the state's struggling. The state's struggling. Why I say they're struggling is when you need to go about it, like I just feel like this way, like you're struggling. You weren't able to gather any evidence in Tyler Robinson's text messages, in Tyler Robinson's through Lance Twigg, his state of motherfucking mind. You guys understand this? You're trying to go about explain that Charlie Kirk was targeted through his fucking pastor? Through what a pastor believes the Bible, Matthew says, and that's what Charlie Kirk believed in. And so because Charlie Kirk believes that way, and Tyler Robinson doesn't. You're telling me that we don't have any evidence of Tyler Robinson having some strong fucking hatred towards this man? And that he's going to fucking Utah to kill him? We don't have that because of what? Because of maybe how he is towards gays or fucking picket religion. I don't give a shit. We don't have this, and that's what this is all about. This enhancement that he was targeted because of his political religious views. Okay, and I'm just like, well, I believe that the defense is right by saying like you cannot bring in somebody else to talk about Tyler Robinson's state of mind. Okay, you're going to use this person to do what? If it was just to say, hey, this is just what Charlie Kirk believed in. I didn't realize that needs to be. I thought we all knew what Charlie Kirk believed in. Why can't we use his own clips of everything that he's ever talked about and how he argues and debates people? Right? I don't know. But this should just tell us that the state needed to go this route. And this dude was willing to say, I cannot argue this in open court. It needs to be argued outside of open court. And they need the death penalty on the table so bad because they don't want this to go to trial. And that's their only fucking leverage, is to try to get this not to be a trial, is by having the death penalty. And you're using it to leverage a fucking plea deal. And that should make every fucking American sick, is that I'm not giving you the death penalty just to make Tyler Robinson take a plea deal. Right? That's what it shows me. And so, but I thought that Charlie Kirk believes, does he, like, if you think about this though, let's use what Charlie Kirk's all about, then you shouldn't be going for the death penalty, right? Like you want to play games? We can play semantics. Is that what you want to do? And if you all want to go about it, that Charlie Kirk was killed because of this, do you know how many people would be in front and the head of Tyler Robinson? And I can put those people actually there just as well as if you're going to put Tyler Robinson there. And there's people in his own circle. So be careful what you wish for. Be careful what you ask for. But All I know is that Charlie Kirk wasn't saying no, okay, to Tyler Robinson. Okay. Charlie Kirk was saying no to other people and putting his foot down to other people who had way more motive to not have that be the case. So, I think that if you want to make this case exactly what you say you're going to make it, good luck seating a jury that is not going to get into that the jury room, and you're going to have people with multiple different religions, okay? And you think that anybody in that jury room is going to be able to agree once you guys start talking about what your religion is? People won't agree for that purpose only. Well, no, I'm not but and so the defense could use that to their advantage too. Get as many different religions into that fucking jury box as you can, and you'll get a hung jury because nobody's going to be agreeing. How about that? But I think for the state to need to have this in a preliminary hearing, you guys, a preliminary hearing. What the fuck are they doing? Why would this be such a big thing for them that they need to have this in a preliminary hearing? Get him on the stand and testify. I'm just going to write this letter. I'm just going to, this is my statement. That's what these 1102s are. I don't know. Every state has different rules and stuff like that. So, again, this will be my first case following, let's see, right, in Utah. What other case? Yeah, because it didn't go to trial. I didn't follow the Corey Richards case. It's crazy. Thanks for covering this, Anna. I appreciate your perspective. Yeah, I mean, my perspective is that of always coming from the standpoint of I don't believe in leverage. Like, you guys say that this is a slam dunk with this man. I just know that I don't think Charlie Kirk, I mean, if you're all about the Bible, and you're all about Christianity, you don't go around killing people. Even when someone does you wrong, you turn the other cheek. And if you're going to talk about the Bible, you can't just talk about part of it. You better talk about all of it. And so I think it's interesting that they want the death penalty because that's against everything that he, you can't sit here and tell me that you're against abortion, but then you're all about the death penalty. Get the fuck out. Makes no sense. If you believe that God brings you in and God takes you out of this country, right? The world, then you would never believe in the death penalty because you don't get to play fucking God. And so therefore it's never even an option to kill somebody. Whatever. I just think that this trial could totally, if they're just the way they're going about it, religion. Interesting. I just recommend, let's stick with the facts here, man. How is, also, Tyler Robinson he has every right to go to a public event too, right? Just because he's there doesn't mean he's the killer. Right? Do you know how many people want to go there just so they can debate his ass? They don't like him. They'll go there just to debate him. So you know how many people that actually go to his things that don't like they're not Charlie Kirk fans, or they have different, views, and they want to go there, and that's the whole point, is to come out and debate. So I think it's wild. I think it's crazy that the nobles said that, yeah, the person in the car was bald and was 3 people were in that car. It's just wild. I would just love to know what the billable hours look like in this case, because everybody's making a big old deal about Brian Cover's billable hours. But I would love to know about the billable hours in this case and what they're being used for. So, because how many tips could have possibly rolled in, if you think about it, right? Before Tyler Robinson, turned himself in. There wasn't that much time to generate the tips, nowhere near like the 7-week manhunt in the Brian Cover case. So I can't wait to hear these numbers of I want them to start throwing out some numbers, like how many tips were turned in this case versus in the Brian Cover case. 26,000. Well, they wanted 26 grand in public FOIA requests for every single tip that just was until the day of the Elantra being announced. Because then I felt that was to flood the tip line. So I wanted everything before that. And they wanted $26,000 to hand over to me all those tips. And they were going to heavily redact them. And the woman, I was like, do you think it's worth it? Like, how much are we talking about redactions? Like, what am I going to be able to tell about it? Can I get like a sample of one of them? And she's like, honestly, no, I don't think it's worth that money. And I'm like, well, are you just saying this so then I don't get it? 26 G's? Are you fucking out of your goddamn mind? For you already have these in some type of like a hard drive, and I'll fly to Utah or I'll fly to Idaho. Here's my external hard drive. Put it on that baby. Just drag the file. Well, we have to go through and we have to redact all this shit. Why? There was no guarantee when you called the tip line that you were, hey, all your shit's private. Like, what the fuck? There's no invasion of privacy here when you decide to call the tip line, a public tip line in. Just wild shit, right? Like, come on. They literally over there in Idaho are trying to use money. They're trying to gouge us financially so that we can't get our hands on the material that will prove that these people are out of their fucking minds. Like, you had all these tips, and did you vet them? Were you able to turn them down and say, okay, yeah, this person doesn't even have a Honda, whatever the fuck case may be about the tip. But since this case is open and active right now, it's not like I could do a FOIA and be like, hey, I want to see all the tips that came in. But when this case is already adjudicated, that's going to be an option. And I'm just curious how that gets handled. I'm curious how many tips we're talking about, and I'm curious how much they're going to charge for that public request. Whatever. We don't take ourselves too seriously over here. But I have no idea. I agree with Katie K there. Why is the state hashing this? Because he knows it's exactly about that. Yeah, but you can do it so many other ways. You can show all this stuff so many other ways, but you don't need to bring in the way that you're attempting to do this is like, you can't bring it in some other type of way for this enhancement. That's all I'm trying to say, guys, is that, yes, of course you're going to make it this way, right? But you have to ask yourself, this is a preliminary hearing, and the state, once they have all of these charges continue on, okay? But this is the only way that they feel like this is so important to that charge. And I'm over here thinking, like, you guys, something that's just admissible is one thing. It's the weight that you're going to apply to it. Okay. So this has nothing to go to the weight of the evidence. If I'm going to admit it, okay, great. It's admissible. I'm admitting it. Great. As the, speaking of like the magistrate here, well, what kind of weight are you going to fucking apply to that shit? because as a magistrate, aren't you wondering the same questions that I'm asking, which is why the hell do we need to go about it this way? You know how many cameras they have, and not a single camera captured him going up on the roof? I find that hard to believe. Or we should ask ourselves, wow, we have all these cameras and, you know, I don't know. Especially the way that the way that that campus is laid out, the roofs of buildings are just like, they're equal with like, it's just so weird. It's just a weird layout, you know? It's because they dug it out, like they call it, like it's an amphitheater, like it's. To hear them testify yesterday that they did nothing in preparation for him to come to town. No meeting, no, hey, Charlie Kirk's coming on town. Oh God, you know, you don't think there's going to be. You're not worried that to hell with him possibly getting anything happen to him, but like your students fighting, you know, what? I mean, we're putting a bunch of people in a small space that have clashing religious views and political views. Are you serious? And you don't think that maybe we need some extra security? Mind-boggling, if you ask me, for the safety of the students on your campus. Very interesting. I can never imagine them ever having a basketball game, like, and them opening up the arena for any reason, like women's sporting events in college or something. It doesn't matter. And you're not having like assignments and security policing. That's like, that doesn't make any sense. Think about that as far as like being a student there. You were just a sitting duck, just like Charlie Kirk was. Just think about if you have like a concert, you know, like, I don't know, wild to me. So the state pretty much has jack shit, but we are on a lunch break here and we begin in 45 minutes. So at 3:45 Eastern Standard Time, which is 1:45 Mountain. I don't know why that all had to be hashed out then. Just like totally sucked the life out of you following this case. You know? I think everybody involved in this should go down. Just like I think about every case. You know, I don't think just one person should go down. I have to involve just one person. And it just doesn't scream like it's been one person. So, curious to see if the defense calls anybody to the stand when it's their turn. I can't wait till we get to this whole Lance. Where is this little shit? This little Lance twig. Where is this? Recorded statement of Lance Twiggs. Why didn't they just do recorded statements of Bethany and Dylan? Oh, wait, that's right. They did grand jury. Recorded statement of Lance Twiggs. Recorded statement of Bethany and Dylan. Let's see what I want to take a peek over here. really quick to what was Candace saying yesterday? Anything? Candace. Has she not been, I don't know, maybe she's not like on a, oh wow, she hasn't streamed in, let's see, live. When's the last time she was live? 10 days ago? What has she been doing? The Truman Show. Proof that Charlie Kirk was targeted by the elites. Oh my God. Is she been on vacation? Where's Candace? I'm surprised. She's on vacay. Imagine she would take that 2-week vacay when it was the preliminary hearing. I wonder what she's. Oh, see, I think that would ruin my. Maybe she just needs to get away from it, but I think that would ruin. It'd be so hard to like not want to be like, you've been talking about it for the past how long? 10 months, and now you're going and you're on vacation during the preliminary hearing. Has she been on X? When did she come back? I know that I can't get over the fact that some guy's gonna say, I started my shift at 11. I turned my body cam on at some point after the shot, whatever, and it only lasted for 27 minutes because it ran out of battery. Fuck that. That is unbelievably. I don't believe that. I'll never believe that. And whatever these deals are they have with the companies that are producing, just like cell phones, we need to be able to tell if somebody turns it off or if the battery, dies. But check out her 4-hour interview on Sean Ryan before vacation. Charlie made himself a sitting duck in a country full of guns. Monday, I believe, but X has been hilarious. So she's been on X. You know what? Let me take a peek. Let me take a peek over there. She's back on the 13th. Let's see. Hopefully she's been giving him hell. Just a reminder tonight, guys, is my big Sunday night live that I didn't have Sunday night. I'm doing it tonight. And I got some bombs for you if you've been following my work with the Idaho 4 case. Yeah. I'll give you guys a little hint. Back in the day, I put out a video of the real timeline, and I showed you guys how that morning before they went to the house, there was 2 events that they flip-flopped, and they put them out of order, and they involve supposedly bringing out the canine, supposedly, drugs, supposedly substances, whatever. But you guys know that I think the Dutch Bros shit was involved. Okay, at least what was going down was right in that area, and we would see way more into it. But back then, when I went ahead and asked I did a public request on both the 2 instances that happened right before the 11:56 call. And they were denying me for the longest time because it was an open and active investigation. And so I couldn't get anything. Well, after the Malwich stuff that I put out last week, we're going to go over a little bit of that. But we're also going to talk about the fact that I resubmitted my 2 requests from back 3 years ago. I put it back in saying this cannot possibly still be under investigation. Like I want everything to do with those 2 calls. So, and I put it out in a previous video, and I'm going to show you guys that old video and show you guys how important it was, because it's like, how does this get mixed up on a CAD note? On CAD notes, how is the times like? So there may be some manual shit going on. But we're going to ask. We've been asking for a lot of crap, so make sure you guys tune in later. She's been following. So that's. I'm doing my big Sunday night tonight because I was spending time with family for the holiday weekend. Oh my God. Candace is pregnant again? Oh, hopefully it's a boy. Does she have any boys? Aren't they all girls? Hearsay is allowed in any courtroom that's preliminary hearing. You can use hearsay. There's just like a couple exceptions. You guys remember, this is supposed to just establish probable cause. Like the preliminary hearing is just supposed to, all the probable cause that you said you had. Now you're going forward and to say that, okay, because this person should be charged with this, right? And so just think about this. They're here at this preliminary hearing, and what have they truly showed this judge? That basically nothing was done, and you didn't know who this was, didn't have pretty much any leads except like, hey, who's this person or whatever, right? And then he just waltzes in and wants to say he wants to turn himself in peacefully and for whatever reasons. Thank you. Goodbye Wednesday. Appreciate that. So if you're supposed to go off of like, hey, what are you showing me? I just have a lot of questions. And the only thing that I think that they have is the potentiality that a kid was so nervous that he would be killed because wait a second, how did I get fucking blamed for this shit? You know? It's like we heard that this Lance Twig kid was all nothing but trouble. So I'm curious. A lot of questions. Oh, 3 boys, 1 girl. She has 4 kids. Then I must be thinking somebody else's kids. That there was just 2. I don't know. Then I have the kids mixed up. They gave Lance Twiggs limited immunity. I knew that they did that. Limited immunity. Fuck immunity. They are not going to make his so-called furry boyfriend go to court, so he will not be cross-examined. Which I think is crazy. I think that's just fucking nuts. So. Let's see, though. Let's see. I know that I think Turtle Boy's already lost his mind a long time ago. I told you guys that. But fucking A. Lucky coming out and saying, I would not go on Turtle Boy's show. I would not do that. Why? Because he said he was going to protect me, and he didn't protect me back then. I loved it. I loved it when I heard Lucky say that. It's like, yeah, you're supposed to protect your sources. Like, you don't do what he does to sources. Just wild shit. But Lucky came out and said it the other night. So, let's see. Oh, what did Ewu Media? 6 pages. Okay, so Moscow lost. They asked for this to just be dismissed. Like, this is crazy, right? Yeah, no. That decision order denying the city's request to dismiss Ewu's petition based upon failure to register, 6 pages worth. And we knew that she was going to deny that, but there's a 6-page order. I'll go over that tonight at the end of my show. Let's see. Candace. Oh, this is our daily reminder that the federal government hates us and thinks we are retarded, she says.
Footage of the alleged shooting.
There is not, Judge.
Okay, I just wanted to clarify that. Ms. Nestor, given that additional information and anything further from defense?
No, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting.
What's alleged shooting? This clip never gets old. Oh, there's another one. They tried to delete this stuff off of the internet to craft a narrative post-assassination. Every PR agent and influencer in the Matrix was sent to attack me day in and day out, but it didn't work. This is Candace Owen, by the way, an hour ago. It is absolutely true that what doesn't kill ultimately strengthens you. They tried to break me psychologically post-assassination, but I survived it. I now feel stronger and more prepared for this fight than ever before. Time to go, Max. I fucking love it. Love it. An hour ago, confirmed that Tyler Robinson is just 5 feet 10 inches. Tons of ways to do an analysis of the person's height walking up the staircase. We've been saying this for fucking ever. Can guarantee you it will now get done by the public. She says, I can guarantee you it will now get done by the public. Byron is trying to prove that Tyler was read Miranda rights before his so-called Discord messages. Really? I'd be interested to try to help prove that. That's interesting. Really? I like Mr. Coleman. An hour ago, this was my exact point. The person walking in the video they are presenting is very clearly a tall person, well above 6 feet. No way that is a 5'10 or 5'11 person. How tall is Lance Twiggs again? She's sharing, somebody posted and said 5'10. The guy in the video looks way taller than that, in my opinion, but what do I know? An hour ago, she says, sorry guys, I refuse to obey the party's final instruction not to believe your own eyes. The video is showing a man that looks to me to be like 6'2", minimal, possibly 6'3". Tyler Robinson is about 5'10". This is before she got confirmation that he is 5'10" in his, like, they have him listed at 5'10" in his docs. Oh, there he is. Tyler Robinson is just above 5'10", just above it, like 70. Lionel says the prosecution's case rises or falls on Lance Twiggs. In addition to being able to link any weapon whatsoever to Robinson, yet the defense is denied any meaningful opportunity to confront and cross-examine the very witness whose statements allegedly established the defendant's admissions. That strikes at the heart of the Sixth Amendment's confrontation clause. Even a live remote appearance by video would have preserved adversarial testing while imposing minimal burden, shielding the prosecution's central witness from examination under fundamental fairness and the reliability of these critical allegations. This is unfucking believable. I have the right to face my fucking accuser. Right? Wow. Wow. Candace Owens repost. Coleman says, a quick rundown of yes. You guys see how I'm in the triangle, right? Now I'm all triangled up. Coleman uses my reference work on a couple of his shows. Now I got Candace sharing Coleman. I'm creating the trifecta over here. We did a lot of work early on in the Charlie Kirk case. We did a lot of work. Give a shout out to Sarah. Is Sarah still in here? Oh, she is right there. Wow, was awesome. Have you watched him? No, Sarah, but since you told me I should, I will. Do you like that? We're creating our own triangle. We got the badge triangle here. But Coleman says, a quick rundown of yesterday's preliminary hearing and a personal message to Andrew, the man so hell-bent on destroying at Real Candace Owens, that he's willing to destroy Charlie Kirk's legacy by calling him a liar and a fraud.
Welcome in, welcome in, welcome in. Guys, we've had a never-ending crash out today from Andrew Colvette. Yes, a never-ending crash out. I don't know if you got to see it. I don't know if his job's in jeopardy, if his liberty's in jeopardy. I have no idea what's going on with this guy. I have rarely, if ever, seen a PR professional crash out like Mr. Colvette has done over the last, I don't know, 18 hours or so. It's been bad. It's been really, really bad. You know, hardcore drinkers do this when they get a little out of control. They get manic. Drug users sometimes do this. I'm not accusing him of either. He might just be undisciplined, but we will examine that as the time arises to do so. But welcome.
Anyways, that was shared about 6 hours ago. Candace, 7 hours ago, says this interview has now climbed to 4.3 million views on YouTube alone in just 4 days. No true words, Charlie. Let them mock and slander. It isn't working. We have the truth on our side. Our government thinks we are retarded. They legitimately hate us. There's another one.
While you were on the roof, did you encounter any spent casings?
As a matter of fact, no, that's why when I saw the prone position where a person would be laying down a sniper, being around guns and snipers all the time, I was looking for a spent shell casing. I couldn't see one. I was looking over the edge, looking all over the place, making sure the gravel wasn't disturbed, and I couldn't find a shell casing at that moment.
And that would be, the reason you would be looking for that was because some types of guns, when they shoot, eject a casing automatically, right? Some
Yes.
do, some don't.
Yes.
All right. And then you also didn't find any unshot bullets. No. Okay.
Unshot bullets. 19 hours ago, Candace Owens says, first it was, quote unquote, Charlie never spoke to her. He was afraid, end quote. Now it's, quote, okay, they spoke and texted often, but Charlie was being fake and trying to. What? No. So to be clear, Charlie sent me pictures of him and his son and daughter in the hospital after birth because he was looking for things to, just pretend we're just gonna keep you right here. Or just generally just texting me when he was worried about Erica was rushed to the hospital in February of 2024 due to a preterm labor scare. All of that personal stuff to simply, You are a clown, says Candace Owens to Andrew. Candace, he was finding things he could connect with you onto what? When it came to the harder conversations, like for instance, when you tried to bait Fuentes into a debate by publicly lying that Charlie had agreed to debate him after without asking Charlie's permission to do that. He made me deal with you directly. I'm sorry you had to find out this way. Oh, then he says a screenshot. Readers added context. Candace's own did not claim Charlie Kirk had agreed to debate Nick. She offered to arrange one if he debated her first. Wow. These people are all going fucking crazy. What is going on Twitter? Wow. "21 hours ago." Ooh, let's talk about bullets. Charlie Kirk, like many young men, adored Jordan Peterson, but noticed the hypocrisy of his viciousness toward people after October 7th. I know because he texted me about it. He was always texted like friends, and we always shared jokes and memes. Zionists will not rewrite Charlie Kirk's history and edit out his true friends. His opinions on Israel were changing. He was exploring, Catholicism. I always told the truth. And then she shares I'll find a funny meme I saw. And I don't like Nick, but this is hilarious. Why is he writing in sonnet form? I need answers. Ha, so true. Such a good meme. Wow. Shit, the internet's on fire. Candace is on vacation, just like, watch this. Ooh, Mel says, and then Candace retweeted it, that Andrew has been pulling strings behind the scenes since day one, trying to obfuscate what was actually happening at TPUSA and with Charlie in those last days, sending out his little spies with tidbits of insider knowledge to bait others into revealing what they knew. He is a dirty, rotten scoundrel in every sense of the word, and I'm so glad people are finally getting a glimpse of his true character. Candace says, and then she retweets it, "Hey, Andrew, the reason I don't share too much of the recent stuff is because it's got a lot to do with Israel and the people that were radically supporting it. Funny memes mocking people, but with your permission, we can go max today. Do you want me to keep sharing?" Oh, shit. Candace is like, should we go max? Oh my God. Candace says, Andrew has been recently sending the narrative, seeding the narrative that Charlie distanced himself from me. Here's Andrew in his own words on a text chain with me and Charlie in May of 2024 denying that charge. Charlie had my back 1000%. His donors were the ones pressuring him, and he always expressed to me that he thought the Daily Wire was behind the sudden push. Truth wins. G, says Andrew, May 3rd, 2024, in a 3-way. Geez, we're not distancing ourselves from you. We have a bunch of donors that want us to, but we deal with them one-on-one. And this website is a resource explaining things. Most of them are fine once we sit and talk with them. I wonder if it's Ben personally or DW. Pretty dirty. Then they have a FaceTime call. Then Charlie Kirk says, Candace, we are with you 100%. And she hearted it. Damn. Candace yesterday shared, Charlie had so much anxiety about our friendship that he was the one updating me on the farce of October 7th. Really weird to continually initiate convos with someone you're scared of. So true. June 18th, 2024 at 4:31 a.m. Damn. That's late. Hey, Andrew. Oh, wait. She just retweeted that. Oh, God. What the fuck is this? Oh, God. Okay. So Andrew tweets, Candace, you and Charlie were not friends. He managed you. He kept things light and polite so you wouldn't turn on the organization. Show me any proof of genuine friendship from the last 12 months of his life, from the last 18 months, from the last 24 months, not some 2018 text, something recent. You gave him anxiety whenever you called or texted asking or demanding to speak at our events. He made me or Justin deal with you and George. This is why when you tried to hire me in February of 2024 for PR, I agreed to go along with it against my better judgment because Charlie asked me to keep you close and protect the org from you. The publicist I tried to hire to run Point prayed about it and felt the Lord told her a firm no, and so I ultimately declined. This is your central foundational lie. You were not his friend. You are not his defender. You were his tormentor. And now you torment his wife and the organization he built. Candace, you are a fraud. Ian Carroll says, oh boy, you should probably take a break from the internet, Andrew. You're putting really unintelligent things in writing. I like Ian Carroll. Oh, for fuck's sake. And then she's like, oh boy. So Candace basically comments to repost that, and she says, I'm glad you finally came to the surface, rat. Your previous employees told me it was you and Erica that were teaming up with the YouTubers to put out the utterly fake narrative that Charlie and I were not friends and he had anxiety. You also worked together to lie about his pull toward Catholicism and to put out the deranged narrative that I secretly loved Charlie and hadn't spoken to him since 2019, despite me touring with him through to May of 2024. Your lies are easy to debunk. I simply could not have demanded to speak at any TPS USA event because we had a speaker contract that rolled over annually. Andrew. This means I never, ever had to beg or even request to speak at any event because I was contractually obligated to speak at every major TP USA event every year. It's also utterly ludicrous to suggest he didn't pick up my calls because I never call. Any person who knows me knows I never pick up or call people, but you lie so much. I am going to accept this easy challenge to prove that you are a liar by releasing every single time I dialed Charlie's number for the last 3 years. As soon as I am back on air, that will be released. Gratefully, telephone logs go back 5 years, 10, depending on who your provider is. I simply prefer to text, and I thank God for that, as I've been able to debunk your lies about Charlie because of that habit. Like I said, your number one problem is you are dumb. I love dumb motherfuckers. And when they run their fucking mouths, it's the fucking best. It's the best. That's why I'm like, dude, Turtle Boy, you're so easy to debunk because you are dumb and you run your mouth. Yep. Damn. Regarding your narrative that we never spoke, I literally just released Charlie and I discussing your partner, Johnny. Here is Charlie captured August 21st, 2025, 3 weeks before he died. He made it clear on stage that I was his friend and he wouldn't be morally blackmailed against our friendship by people like you. Also, the night before he died, he texted you guys saying he wanted me back at Amfest after your Zionist backers demanded I be put on ice. Why did he text Justin and tell him he wanted me back? Do you deny that that happened? Those were again Charlie's words, one of the last wishes he expressed. So was Charlie lying to his audience and to his team in private conversations weeks before he died? Andrew, or are you simply a special kind of demon for attempting to rewrite history and convince the world that his real friends were people like Ben Shapiro? Yeah, fuck that. And the very Zionists he was fighting against for his freedom. Despite the millions of dollars spent, the world sees what is real. Truth cannot be destroyed. Neither can Charlie's voice. Here it is.
Relationship with Candace Owens. No, she's a great friend. You know, look, I don't agree with everything Candace says, but you know what I don't do? I don't stop being friends with people just because people morally blackmail me. I don't do that, and you shouldn't either. Honestly, I traveled the country with Candace. I went to her wedding. I saw her meet her husband. I went to Israel with Candace, which is a fun story I'll tell you at some point. I think the world of Candace. She's a great mother. She certainly has very, very fun opinions at times, and she's a great talent. She says a lot of stuff that sometimes I don't agree with, but that's what makes our relationship and our friendship interesting.
Sigmund Freud was a Satanist, full stop. He wasn't.
There you go. Feels good to finally get to the final boss of the PR. Yeah. We're over here giving, I'm in the official triangle.
Why are you doing that hand signal?
Because I'm making a joke about it. Because I said that since Coleman is, repping my work, and Candace is now retweeting Coleman, that I've created a triangle with me, Coleman, and Candace.
Yeah, but don't ever make that hand signal.
What up, motherfuckers? You know what? Let's do another one of these. Let's do some sake. It's about to be happy hour here. They're wanting to see what their boundary limits are when it goes to trial. We shall see. We shall see. I think, oh, thank you, Heather. You, Candace, yeah. I'm just all about, like, come on, man. The documents. Let's just go get the documents. Let's go get this. Let's go get that. Like, let it speak for itself, right? We don't gotta fucking put no narrative on shit. Like, and then when you get whatever, then you start asking the questions based off of the shit. But it's the people that fucking start yapping before they start producing. It's the people that have to put a narrative before something that they release. And that's exactly what we started seeing the state talk about, why they have to have this dude in his statement about what Charlie believed in, didn't believe in, and hey, this is a targeted, attack because of Charlie's religion and Charlie's political views. And it's like, that's how you think that you need to get this in for this enhancement? Get the fuck out of here. Okay, there's so many other ways to get that in. Ridiculous. And just tells me they don't have it. Oh, Sarah, dude, you in on the triangle. We have all the nooks and crannies because each triangle little, angle there. You got to have a connector to your triangle. Sarah's the connector. We got to have a blue wrench everywhere. I don't know who he confessed to. If we're talking about that he confessed to Lance Twiggs, please just shoot me now. I want to hear more about his parents. So we'll see. We'll see. Just like I said, just give us the material. This preliminary hearing has more fucking distractions. I don't know how people with ADHD or ADD can follow this preliminary hearing because it's all over the place. Like, you need an index to be able to follow this preliminary hearing, which would just be so straightforward. It just can't be. So, well, his wife was looking more planet every day. You know what I said though? Like she played basketball at a school, and so I was trying to go back and look at some of like her basketball career. But Bella's like, have you seen her picture when she was in high school? She's like, go look at it. So let's see. Yeah. Ah, yes. We're going to do some hot sake today for happy hour. Oh, it's cold? Okay, cold sake. And Michelob Ultra. Cheers. I'm sponsored by them. Michelob Ultra, you better start sponsoring me. All right, what do we got here? All right, we got down to 10 minutes. I got us down to 10 minutes talking about Candace. Candace comes back next week. Yes. Yes. Let's see. Let's go back to our girl. Candace, let's see what else she had to say. Today, the Tyler Robinson show trial begins. Candace calls it a show trial begins. Evidence like text message confessions will be allowed in the courtroom, despite the fact that Tyler's defense has not been allowed to vet those messages to determine if they were doctored or who actually sent them. Remember, the FBI and ATF was not forced to turn over key evidence despite multiple discovery requests because the judge has ruled it's not necessary at this stage. Key witness testimony from Lance Twiggs will be played, but Lance Twiggs is not allowed to be cross-examined because the judge has ruled it's not necessary at this stage. Today is about emotion. You will hear the Fed's narrative absent any ability for the defense to meaningfully dispute it. What you can expect, aside from Erica's tears, are an orbit of her payrolled influencers trying to convince you that the unvetted evidence is overwhelming and undeniable. In quotes. Sit back and watch the predictable show. The real trial will come later. Charlie's army is growing. Ultimately, truth will win. Interesting. You know, I know that back in the day, you know, Candace was talking to certain people, whatever, and then we were all wondering, did Candace ever get a chance to talk to Tyler Robinson's parents? Did that ever happen? Does anybody know that? We are out outside about 5 minutes, about 6 minutes. Probably the judge will sit down. Because I get it. Like, if I was Tyler Robinson's parents, I would go get attorneys and I would have them write Candace and say, like, I want to speak with you with my attorneys present and see if there's a way, like, yeah, can you, if like you really need help, like whatever the help may be, because I'm just saying, is the state really going to be working for Tyler? Does he need some private attorneys? Because if there was ever a reason that anybody should take on I'm going to donate $1 for all the people that watch this shit, donate $1, we could publicly fund a private go for the kid. So just curious. The crash out from the Sean Ryan interview should be studied. This young woman enjoyed it so much, she's angry. LMAO. God, holy shit. This dude is like spiraling. Cheers. Go Candace, go get them. Fuck them all. That's awesome. I guess Coleman just revealed that Johnny Moore, Andrew Colbett's business partner. Wow, he's the one that did that. I didn't realize that. Let me see.
Doing a little research on NCRI. They've added someone new to their staff here in the recent past. Network Contagion Research Institute appoints Johnny Moore as a senior advisor on Middle East affairs and associate director. Look at the date line there. May 20, 2026. It's July 5. We're talking 5 weeks ago. Engaged directly with Congress and worked alongside yada, 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 yada. His appointment reflects NCRI's continued expansion into national security oriented. Okay, well, who is Johnny Moore? We did a whole show on him. I don't want to go through the whole show we did, but we previously talked about a business he had called Kairos, K-A-R-I-O-S.
Yep.
And we talked about someone who helped found Kairos with him. You might recognize this feller. His name is Andrew Colbett. That's a very old picture of Andrew there. Here it is. Vice President of Communications, the Kairos Company. Experienced communications marketing professional dealing with major brands, nonprofits, and high-profile thought leaders, authors, and commentators. Oh, I think I get it now. I think I get it. I think I know where we're going here.
He did not like Bibi Netanyahu, and he said that to me many times, and he said it to people around him many times. He felt that Bibi Netanyahu was a very destructive force. He was appalled by what was happening in Gaza. He was, above all, resentful that he believed Netanyahu was using the United States to prosecute.
Yep. A lot of things are, I mean, this case could bring down fucking so much, can bring out so much shit. It's just, this just depends on how this plays out. Do you guys know this can't go to trial? I mean, Jesus. Do you want to know what would come out in this shit? I mean, because this judge is just letting everything in, right? You know? So if that's the case, you're going to set precedent here. They shouldn't want this to be a death penalty case. But then they're nervous if it's not. Then they go to trial, and then a bunch of shit comes out. It's pretty wild. All right, guys, we're looking at 2 minutes until we start here. 2-minute warning. If you got to use the restroom, not like there's going to be any fireworks, but 2-minute warning. And it'll be a new witness. Can you believe that? We're only going to hear witness number 3. Look out. Witness number 3. Woohoo. We're really getting somewhere. Simple Me Too says, I don't think his defense has the balls to expose it all, even if they even know. Yeah. Tucker went max on July 10th, and BB was with POTUS here in States through the end of the day on the 12th. That's when plans were made. That's what KDK says. Well, we will see. We are 1 minute outside. Again, if you have to use the restroom, not like you can't break away. And let's see. I would like to add, Candace says, that from day one, I've noted you are not very smart. You strike me as someone who doesn't conduct his own research and just copy and paste what other people say. Case in point, you quite literally copy and pasted this tweet from another user. Can you try thinking your own thoughts? Let's try this assignment a third time. I've been making this claim since at least October, publicly. Find me one clip or tweet of me asserting that I was told it was $150 million. My story has not changed. You specifically told me that BB offered to take things to the next level. You never said a specific amount. Staying consistent is easy when you're telling the truth. Reading comprehension is especially hard when you're a liar who doesn't do his own work. At Andrew. No, Candace. You don't get off that easy. You're the one making the explosive claim. Israel made an offer to Charlie, TP USA, or the Charlie Kirk show now, LOL, to take Turning Point to the next level. So where is your proof? It's a simple question. And no thanks on watching every episode. Your central claim is literally in this thread. There is no question an offer came in, though. End quote. But there actually was no offer, was there? It's a complete fiction. An internet rumor you recklessly repeat with maximum confidence, because if you say it with your chest, the internet will believe you.
Basically, it was 2 weeks before he died, and I'll never forget it. There was just some annoyance that was, in our way, and we needed to deal with something. I can't even remember what it was, and I just remember going, hey, we could just tell them XYZ. In translation, we could just, little white lie, and it'll go away. They'll understand. And I remember seeing the dots. He was typing right away. We don't lie. It was a private message with me. I love that. And it wasn't, you don't lie. It's not, I don't lie. It was, Andrew, we here on the show in this Turning Point, we don't lie.
Bet you didn't see this.
We don't lie. God, he's just getting crushed. Andrew told me that BB offered to take Turning Point USA to the next level and that Charlie turned him down in the Hamptons.
This is my theory. There's a lot to see here. Because you were lying to cover Bibi Netanyahu's tracks. That's very strange. You were there when Bibi Netanyahu called. Andrew told me that Bibi offered to take Turning Point USA to the next level and that Charlie turned him down in the Hamptons at the dinner that you were a part of, but you don't remember that part. You say he's just calling about a letter that Charlie wrote 5 months earlier. The dinner that you thereafter allowed an army of influencers to claim never actually happened, but you were there. Oh, I was there every step of the way. None of this ever happened. Nobody wanted to address BB calling. Nobody made any statements about that. Full-blown psyop, psychological operation. Truly, everything that you guys did, not only was it cruel, but I think the real motivation was you just thought you could psychologically break me. Because that's what this whole thing has been one big psyop. Very well funded because there's a lot of money on the line.
Wow. Everybody's going ham on Twitter, but here we are. Day 2, the third witness will take the stand. Let's see what happens. Again, welcome into the transparency. Appreciate you being here. You could be anywhere watching it, and you're choosing to be here. It's probably because of the chat and the no fucks given approach about so many important fucks, though. Okay, let's go. Let's get the show on the road. It's happy hour. We had Argentina come back and win today. Woo, explosive last 12, 15 minutes by Argentina. They were down 0-2, man. And then it was just raining red cards, yellow cards. So when's the furry take the stand? They're saying that he's not. They're saying that he has limited immunity and that he just gets to give a statement. So who the fuck knows? Katie K says, don't go up against Candace, man. She's, in quotes here, she's a total fucking beast and almost always right. I'd want to make sure she's always on my side, says Katie. Thank you, Katie, for your thoughts there. Remember, it's only now it's 1:51, so he's 6 minutes late. They bill every 6 minutes, these attorneys. So they don't bill during their lunch hour, though, right? Can we cancel this and just go to trial? I mean, yeah. I don't know. 6 minutes is expensive. The lawyers bill every 6 minutes. So here we're working on this second set of 6 minutes. There's a lot of lawyers in this room. In Utah, the taxpayers of Utah are paying for every minute of it. Let's just make sure we got all the... Here we go.
All right. Mr. McBride. To the state.
There we go.
Yes, Your Honor. Just by way of preview, we are going to call Jen Falmuina, Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time. And we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
Oh.
Like to come forward and be sworn.
Lana, you may not like Candace overall. What are you talking about? I like Candace Owens. I have no idea what this comment is for. Okay, she's with the FBI.
Situated. There should be a bottle of water to your left. maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment
SBI.
on September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means Evidence Response Team.
Yes.
Were you called to the crime scene at Utah Valley University on September 10th, 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent? Do you know?
It was sent back to their equivalent of our crime lab.
Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt
It was
action?
a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody. Then eventually it was provided to the ATF lab.
Okay. So the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31.
So we have the screwdriver, the long gun, and the towel. The gun eventually made its way to the ATF, and the towel and the screwdriver stayed with the FBI for that lab. But the FBI then sent the gun that was packaged to ATF. And so we're looking at
That's connected to the defense computer right now. Anyway, to switch it.
Exhibit 31.
Thank you.
FBI DNA report is
I'm
the
showing
towel.
here on
and
the
screwdriver.
screen, State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment. And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that in fact the report that you received documenting the testing results on these items and some other items from the
Yes.
FBI?
Sorry, yes,
And does it appear to be in an accurate condition as to how you received it?
yes.
I'd move the admission of State's Exhibit 31.
Defense? All right, so I'll note the standing objection and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
Anything further, Mr. Burke? All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to, still on page 1,
Here
where
we
the screen will
go.
show items 7 and 8. Sergeant Falmuina, do you see the lines that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, towel from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it
On
is.
September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burke.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So we've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right, the court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twigs. The DNA results from item 7 sub 1 and what are 1.7 octillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined
Yeah.
line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twigs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twigs is?
Yes.
Who is Twigs?
Twigs is Lance Twigs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twigs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
Right. Mr. Burt, cross-examination. Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
He's the one that asked for that.
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the parties?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you.
Was he not paying attention to what the fuck was said in the beginning?
All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker.
Amanda Baker. So out of order because they have to accommodate for her schedule. She's witness number 4.
All right, Ms. Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
And she's actually a defense witness.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Ms. Baker, if you wouldn't mind being seated at the witness stand. Once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we
Okay.
could.
Okay, remember, this is a
We're
defense
doing that. Good
witness.
afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Bakker.
Oh, okay.
Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority one level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing. For example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number, State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
Mr. Bird, are you requesting it to be
Oh, here.
displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? and highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says 1 of 6.
Yes, so this would be the entire document.
Mr. McBride?
I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in her report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Well, that's just like the Kohlberger case.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct. It was not.
Okay. And then the next one, not that one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
Can you
sorry.
take that down?
Can you clarify your question?
Yeah, when it refers to don't state that there is a 0 error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
A human error could be an error.
Mhm. Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's up. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
A formal activity level is determining an activity that causes DNA. to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation based on my experience that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data? So item 8 was the screwdriver from the perch. I would say that there was some degradation as I look at the DNA peaks or the DNA data. In an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information. I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of A, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length.
Correct, yes.
Okay. Now, for the, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex determining locations. That lets me know if an individual is biologically a male or a female.
As between 2 individuals, 99% of their DNA is exactly the same, right?
That is correct. And that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what it differs amongst us, with the exception of identical twins.
But with the within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So locus is that individual section of DNA.
Right. And they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex determining locations. One is Y-indel and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay. And then for the other locations you're looking at, those you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
7.
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations.
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare it to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes, so for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, so DYS 391 is actually that male location. So he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now for that loci, you'd expect 2 types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson's a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing 2 samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sin?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing,
Yes.
all right? And then by the same organization, National Resource Council, the evaluation of forensic DNA evidence,
Correct, yes.
published in 1996. Are you familiar with that as well?
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI, named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing,
Yes,
familiar with that. Forensic DNA Typing Methodology,
yes, I'm familiar with that one as well.
and Forensic DNA Typing Interpretation.
Yes,
Everybody in your field relies on these publications and use them as teaching tools.
yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes,
This case, we're dealing with mixtures, correct?
yes,
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is dropout?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1450, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident based on our validation, our testing, and my training that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14, 15, I will not automatically exclude them.
What is stochastic effects?
Stochastic
I'm
effect,
going to object at this point. I think we've gone beyond the scope of preliminary hearing. Because of getting into 702 material that's not necessary for the probable cause determination.
All right.
I think
Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question and then I'm moving on.
Mr. McBride?
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates a likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
And how about for the other sample?
For item 8, one of the contributors was 11% and the other was approximately 89%.
So,
Correct, yes.
and the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of
Objection,
Investigation?
Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence to the stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state. And I think we're beyond that point now, getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAS report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, is it not?
Not necessarily.
But it can be in some cases, correct?
It could be if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same. It could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce.
I believe so, yes.
Federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that a publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay.
Well, who the fuck would they be, you dumb bitch? Ain't me writing that shit.
But it's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Are you,
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where again the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's.
I want to know why she picked only 2 individuals.
Thank you, Mr. McBride. Mr. Burt.
Talk about
Your
that.
Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these 2 samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors
Yes!
analysts
Pass my
puts
test.
into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors.
Woo!
And I will show to the court why she changed her analysis.
Woo!
And will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and asking the court to give weight to them.
Yeah.
And I'm asking the court to consider how those numbers were arrived at and whether there are
Fuck yeah,
reliability
bitches.
issues with regard to those numbers.
So the concern that I have.
Oh, fuck off.
is- I turn to State v. Ramirez, 2012 UT 59 at paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate,
Sure.
I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is as we go down further down this path, which again, is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause?
Let's just ask her.
Sure. And I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other
Yeah.
reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments. Whereas I'm focused on what the court ruled, which is we have to look at reliability here. And that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B 4, this the Exhibit 31 is considered reliable hearsay. In addition, credibility determinations are not proper for the court to make here for the whole reason that, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that. And a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is to determine probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. Well, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile. If I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
That even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how Star Mix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run Star Mix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time. But even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365?
Okay, this should be good.
Stand up for the witness.
Case notes, tab 4.
Let me know when you have that in front of you. I think you need to scroll up one page. There we go. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons.
What?
And compare it back to my conclusions.
Wait.
Right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms or the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
Move into evidence page 365. And that would be Baker 4.
Mr. McBride?
I'll object on relevance grounds.
Fuck off.
Do you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors. And I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right, so as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, these notes were prepared as part of the report in State's Exhibit 31. I will find that it is
Your Honor,
relevant
Your
and that it is admitted into evidence as regards to publication. What is the request?
Your Honor,
Mr. Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that from both sides. I want to make sure. I want to make sure, are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
just trying to put it together here.
How do you not understand this? It's really fucking simple.
So the question I'm trying to get to, counsel, is, was this particular, I recognize it as it being prepared by someone else, but as it relates to States Exhibit 31, was this relied upon in order for States Exhibit 31 to be put together as the report?
Yes.
Because I'm trying to determine relevancy.
Yeah,
as it
because she
relates to
switched
that,
it.
And that's a critical point I don't have the answer to just yet.
Ask her.
Okay.
Ask her the fucking question.
Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those two reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have one reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions.
You could
and
have
additional reviewers.
cross-contaminated.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
Anything further from the parties before I weigh in on, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published.
All right, in the courtroom.
In both the courtroom and to the cameras.
All right. Any objection, Mr. McBride? All right, go ahead and publish that to all screens and may be captured by the media.
My God,
So
this is fucking crazy.
These notations at the top there, 7-1 male, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, She determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3. So we had a discussion as to why she thought it was 2, why I thought it was 3. And she said she agreed with me calling it 3 based on our discussion.
Wait.
So was that an extended discussion you had with her or just?
No, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it
we're
is.
Talking about? All right, thank you.
Wait, so
Now, I want to ask you to look at page 128 of that same exhibit.
why does her thing say 2?
No. Is this an electropherogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
128.
Yes, it is.
I moved that into evidence, Your Honor. This would be Baker 4, page 128.
Baker 4.
Oh, I thought I already admitted Baker 4. Is this a different?
Baker 5.
The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
Oh, okay.
Oh.
So
And
Baker,
so this is Baker 4, page 128.
right. So the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I can have just a minute to update my notes on those page numbers.
Yeah, sure, because it takes so long to do that. It's like I already just
365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
First, I'll note, this is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be, these are going to be offered as exhibits. So I'm looking to find them in my file as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here. And once again, I think these are appropriate questions to raise in a 702 hearing. But when, with the standards that apply at the preliminary hearing that I've already discussed.
What do you mean?
The scope of probable cause determination as we dive into.
This is shredding the reliability of the shit that she's testifying to.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropherogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropherogram to reach the conclusions that she reached, that there were 3 and not 2 contributors. And I think it will assist the court in determining exactly how this comparison process works and what the output looks like, so the court can see exactly how the interpretations are being made.
And is this the notes that were relied upon I'm viewing today's exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent.
Yeah,
And that
seems like it.
people can read these things in different ways.
Holy shit, I never knew that you could
And
do
so,
that you could
I
enter
think
in your
it
own
will help the
contributors.
court understand exactly what's being compared here. You've got peaks on a line, she will say, and just to let the court know in responsive to Mr. McBride's statement that he was unaware that this is going to be an issue. he and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation.
He fucking just called
and
him
this
out.
particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
Oh, he says no.
Under Utah Rule of Evidence 1102. B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can.
Was that a yes? Oh, okay.
Yes.
All right. So published, I'm assuming to that
Yes.
screen as well. All right.
Correct.
It may be published. Council, just as a reminder, as this is a probable cause, I understand and I appreciate you give me a pointer of where it's going, but just as a reminder, as probable cause, it is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
Understood.
All right.
Thank
you, Mr. Burt.
Okay.
Dude, I never knew that you're the person that gets the input. How many contributors? Like, holy shit.
Is it true what I just told the court that you pointed this particular page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropharogram?
Yes, this is an electropharogram. Each of those rectangles at the top, for example, D2S441, that is that small segment of DNA that I referred to earlier.
Mhm.
And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after you get this electropharogram, not through running it through STR-Mix. There's a different device that you use to produce these electropharograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropharogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize. But there are parameters. So the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 1, 2, 3, 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see. So how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433 and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine, could there potentially be a third person included? So for example, at D2, the location farthest to the left, I'm asking myself, that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
What?
And when did you change your conclusion?
That I would have to refer.
Sure.
3 contributors, then she changed it. So she does all of this and has somebody saying, yep, it is 3. And then she changes it. Oh my God. Candace Owens is going to lose her shit. Everybody's going to lose their shit. Welcome to Truth and Transparency.
I changed my conclusion on September 13th of 2025.
The next day?
Why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use the phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
Wait a second. You were
And you said you had a conversation with the investigators as to whether Twig should be included as, where you talk to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay.
Why did that
But
happen?
in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor.
Yes.
Do you not?
I do. And with elimination samples, that's slightly different. So
What?
for example, let's say I have a sexual assault case and I have a vaginal swab from a female.
Yeah, but you know
She
whose
has a
badge it
consensual
is.
partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that
Yeah, but who is taking ownership of the screwdriver? That's my badge. You get what I'm trying to say? Understand? Badge, screwdriver, what?
consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect?
Exactly.
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly, but in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Bullshit.
Right. Did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present.
Exactly.
That is correct. It was found outside of a home, but again, based on speaking with the investigators,
What did they tell
had
you?
information to suspect that that towel came from Mr. Robinson's home,
bullshit.
and I should utilize Mr. Twiggs as an elimination.
Who told you that?
Right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up StarMix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time
It'd
to
be a
take a
great
15
time,
minute?
Aaron.
All right, let's take a
Okay.
15-minute break.
I need a break. My
Let's
brain
see.
is fried.
We'll come back at 3:50. Court is in a brief recess.
They were not going for 2 hours. That was an hour and a half, right? Yeah. Because he didn't start until almost 3. Kiss my, right? I mean, almost 3:45, almost, I don't fucking know. Oh, God. 1:30, yeah. They were going for 2 hours. Whatever. Oh my God, my mind's blown. My mind's officially blown. It takes a lot to get me to this point. Oh my God. We just type in what we think is the contributor. And then if what? Somebody doesn't call you up the next day because you did this on September 11th, then September 12th, someone calls you and says, hey, we know that this was in a bush and we know that the screwdriver was on the top of a roof, but we believe this dude's DNA will be on this. So can you do an elimination? What? Excuse me? Why? But then now I'm confused because is it Mr. Twiggs is the one with the mass. Let's see. Yeah, Tyler only has 11%, right? Twiggs had 89% on item 8. This is all relevant because this is all they're relying on is the goddamn DNA. And now oh, boys. Damn, would I believe that Tyler Robinson got set up like a bitch. Ooh, Twiggy poo. Get your furry on, boy. Drop down and get your furry on, boy. The lab should supply all known DNAs to both prosecution and defense and let them deal with it. It's crazy, man. I don't even know what to say right now. Boy, oh boy. StarMix. Sounds like a radio, like a channel, like when you're driving. StarMix 107.9. We're here playing nothing but the hits. We're just mixing up your tunes. StarMix 96.3. Playing nothing but the soft, the soft hits. God bless America. So now, then we're going to hear from Twiggy Poo down the road here. And Twiggy Poo is the one that's throwing Tyler under the bus. When they saw the results and they're like, oh God, no, we have to have Tyler come forward. Or not Tyler, we need to have Twiggy Poo come forward because our FBI person says that there's 3 contributors. Well, not when she gets a hold of this freaking guy. Then she's going to figure it out. You know, I don't know. I don't know. I think Twiggy Poo has a lot to do with this. And why the state is just allowing, I mean, if I'm Erica Kirk, nobody gets a pass, right? Like that's how she should be. It's just like, it shouldn't even be about the death penalty. It should just be like, nobody gets a pass, whoever was involved with killing my husband. You know what I mean? Like, but woo, Twiggy Poo. What's Twig's background? CI for FBI? Who knows? Like we're gonna be able to know that. Damn. Not only did the reviewer say that there was 3 contributors, then all of a sudden the only reason it gets changed is because she has a conversation with the investigators, which she does not recall exactly what was said. And it's like, I wouldn't give a shit what you guys told. Like, oh, here we think that this would be on there. This dude's DNA is going to be on there. And he's the major contributor. I don't know. You would think that if it was Tyler handling all of this stuff right, like right then and there, like sweating on it, like, I don't know, wrapping the freaking long gun, that it would be a majority of Robinson all over the towel, all over like the screwdriver, that he's just handling it to do whatever, right? He wouldn't be the minor contributor. He'd be the major, especially since you got the item right away to test it. But guess what? We have some the testing of the DNA. It's like what do you call it? Degraded. It's degraded DNA. Why would it be that way? Degraded DNA. There was some degradation on the screwdriver, and it was slight on the towel, not as much as a screwdriver. But I think this reliability blows. I think what it looks more and more like is that why not just take Twigs down? You know? I would love to know where Twigs was when the shooting occurred. I've always said this. I said 2 gay guys that are, you know, basically U-hauling it. Homie's not going and leaving by himself and leaving and jug tits behind. Just happened. Like, hey, you didn't come home like last night. You know what I mean? Like, come on. There'd be so many of those have a text. I don't know. Everybody can just get straight effed. This case is really frustrating. This is the like, I hate these objections. Objection. This is just you know, a preliminary hearing to establish probable cause. And it's like, can you imagine if Idaho 4 would have had a preliminary hearing? God bless it. Boy. Neither of these 2 idiots did this, in my opinion. Twigs was jerking his rocks cocks in a closet somewhere. Somewhere over the rainbow. On Star Mix 1079. Oh, shit. Now I'm a believer. I couldn't leave. supposed to be 5 days at the rate we're going. This preliminary hearing is going to last a fucking month. And this judge has no control. He just letting everybody be heard today. Today is Tuesday. Next thing you know, today is Friday, August 30th, and we're still in the preliminary hearing. Oh boy. But remember what I said, be careful what you wish for if you're this prosecutor and you want all of this fucking stupid ass shit in here. The defense is going to get the same. Like, what do you mean it's relevant? This guy wants to freaking get the Bible verse from a guy that wants to talk about what he believes that Bible verse meant and blah, blah, blah. Okay. But we can't understand why she went from 3 contributors to 2, even after peer review. That said 3. Give me a break. But see, the judge did the right thing. He's like, yeah, no, I'm going to allow it. Because I mean, that tells me that he wants to, yeah, it goes to my decision, right? You guys submitted a report 31. That's the DNA. Well, let's break down how this whole fucking shit happened. I've never seen a preliminary hearing take so long. I mean, they were expecting a week for the Kohlberger case, but remember, this is the defense's witness, but they had to go out of turn, which I think totally helps for ratings because this was boring as shit until this witness basically gets called because they had to take her out of order because she's a busy FBI person. And so that's why the defense, you guys, this is just direct examination. Okay. And so I want to know how the state's going to cross her up. I bet you they say, like, what, no questions? This is an FBI lab worker. FBI. So this would have come like after the state put on their case, but they had to go out of order. Maybe she had like dude, I have vacation I have planned. Like, I mean, I'm supposed to be going to like the World Cup, man. I got to get the fuck up out of here. Who knows? All right. They didn't have to argue it. The defense argued we've all known this. The defense argued they never had a suspect until exactly they just had a person of interest. And the reason they're saying they had a person of interest is because they're just using this picture. Okay, they did not know who this person was. They had nothing. They had nothing. And it wasn't, again, until Tyler Robinson saw his face blasted everywhere, right? Supposedly, allegedly, and it was like he wants to just turn himself in peacefully. Because he doesn't want to get killed or something like that. But I don't know. All I know is this preliminary hearing is making a lot of people that have been talking about this case look like fucking idiots, and I love it. Mainstream media. Keep slobbing on the knob, baby. It looks so good all over your face. The only people that look good in any of this are the podcasters. We put it out on the radio. They were looking for a different coloring car. We put it out. We put the radio out. We put a lot of shit out. We put out that there was 2 cars working in tandem. Yeah. On Star Mix 106, the alleles are soft, but the peaks are high, and the beat box cars are bumping. Yeah, there you go. Just join us over here at Star Mix 106. Yeah. The alleles are soft, but the furries are hard, and the peaks are high, and the beat box cars are totally bumping on this traffic jam. What's today? Tuesday. So no one better to watch it with in our Atlanta brains. Yeah. Well, you might have to watch the last hour yourselves because I developed a headache here listening to this crap. Yeah, but that was the first thing I heard when I heard Star Mix. I'm like, oh man, Star Mix, it's like a radio station. 107.9, 105.7 Star Mix. So I don't think I'll ever think of Star Mix the same. Then we get to find out that, hey, we just get to pick our numbers for Star Mix. We decide. She decides the NOC, which is the number of contributors. How have we gone this long and just found that out? I always like to hear what lawyers have to say about it. I'll be interested to turn into Andrea Burkhart for a couple, takes on her parts. Just about that. That's all I want to know is about the Star Mix stuff. I'll be turning into Coleman to see what he says. I'm going to check out, obviously, What's Her Tits, Candace Owens. And yeah. I mean, I definitely want to hear Twiggy Poy's statements. We're definitely going to continue to cover it. But, dude, my brain had that was just overload right there. I had to stay focused, and I just wasn't wanting to. But I did it. DMC all the way, a.k.a. Lady Di 2 over here. She is our evening DJ at Star Mix 106. There you go. Star Mix 106 here in Orem. We just spotted a challenger. Radio's blasting, playing. I wear my sunglasses at night when I pull up at 12:35 on 9/11 to have conversations, so I could be seen more on camera, and potentially with officers wearing body cam. They say that Robinson had a conversation with a Spanish Fork officer at 12:35. Wild shit. What's up, bro? All right, back at it here. Star Mix 106, where the alleles are hanging and the DJ's banging. Okay. Hell yeah, calling out Lana as the tits. Carson, what's up? What's up? I want to be What's Her Tits on Star Mix 106. Did you know that when you're dealing with Star Mix, this allele shit, you can just enter in your own number of contributors that you believe as a lab worker, as a forensic scientist. You can just look at this and you can just say, you know what, this to me looks like a three-person contributor. So you just get to put that in, but you get to pick it. And do you know how many contributors they say were on the screwdriver and a towel until law enforcement decided to poke their little dicks in there? 3. Then all of a sudden, Lance Twiggs comes along and he just is like, here, take my DNA, eliminate me, baby, because I know I'm all over that shit. That's my cum rag. And whoops, he's the major contributor at 89%. And then they want to say, oh, it's got to be Tyler Robinson here with 11%. Well, I don't know who could possibly be handling a towel that's covering a gun and you're running all over with it, and how you cannot be the main contributor.
How would it be 11% if there's 3 contributors?
Oh, because then they just changed their mind because law enforcement said to. This is the wildest fucking preliminary hearing I've heard in a while. It's pretty good. They just got a little bit longer. I might just do a little recap on the second portion here because I want to see Columbia play.
Columbia's almost done.
Yeah, it's sushi night. I don't feel that this analysis is convincing. I just how long till this is over? I just gave a recap to Bella for her 30-second recap of what was happening. How did we do, guys? All right. You guys can finish up with the rest of it. We'll be live back tonight at 9:30 with my Idaho stuff. And then tomorrow morning, well, whatever time we kick it off here, because tomorrow's Wednesday, so they're only going half a day. So they start at 1 tomorrow, which is like 3 our time. So we'll be live 3 tomorrow, and I'll run it. I got to eat some dinner. Got to watch some soccer, and then I'll be live at 9:30. So thank you for joining me. I know that you guys have a ton of options out there, and I'm just flattered that you join me over here at Star Mix 106 every day, pumping out nothing but the hits, nothing but the motherfucking hits. We'll see you guys in the next one tonight. Until next time, peace out, rock out with your cock out, jam out with your clam out.